Hi, Kathy. How are you?
Good morning. I'm just doing great. How about you?
I'm okay. I heard some sad news though yesterday
Oh, yeah?
that you may be leaving us.
I may be. It's been a difficult decision, but being on the SNLG, that's been keeping me really busy, the
I
state and
can
local.
I can certainly understand it.
And I'm having a really, I feel overwhelmed at times. I'm having a hard time keeping up, but I'm feeling guilty, very, very guilty.
don't. You have to take care of yourself.
And being on the town council, I'm extremely involved in that too. And it's like, wow.
I certainly understand. We will miss you though. I could tell Ann Matlack was trying to poach you the other day when we were in the Augusta Civic Center when I was joking around. But it's these are really challenging times, and to be doing two committees as a rookie and town council. Be careful what you wish for.
You're exactly right. And I want to contribute,
Yeah, no, I understand. It was nice to see everybody in person last
It
week.
sure was.
Good morning.
Good morning.
Good morning, committee members.
Good morning.
Everybody recovered from our marathon last week?
I've been working nonstop since.
Yeah. Yeah.
Yeah.
I was up and working at 6 o'clock on Friday.
Wow.
Oh my gosh.
Oh, man.
That's
I made it home,
exhausting.
Kathy.
I think we've got, we're getting closer to a quorum. We need a couple more folks to join, and I know they'll be here soon, and then we'll start with our committee meeting.
How was it, Lou? Whoops, I'm sorry.
right, it looks like we have a quorum. And so I think we'll get started. Good morning, everyone. This is the meeting of the Joint Standing Committee on the Judiciary. And this morning we'll take up two bills. We have public hearings on two bills, and then we'll do a work session on a couple remaining sections of the biennial budget. And we'll start in our usual format with introductions from committee members. And we'll start with you, Representative Downs.
Good morning, and thank you, Madam Chair. My name is Kathy Downs. I represent District 130, which is Bucksport and Orrington. Thank you.
Thank you. Next, Representative Libby.
Morning, everyone. I'm Laurel Libby. I represent District 64, and that is part of Auburn in all of Minot, and I live in Auburn.
Thank you. Representative Poirier.
Thank you, Madam Chair. Good morning, everyone. I'm Jennifer Poirier. I represent House District 107, which is all of Skowhegan and a small part of Madison.
Thank you. Representative Evangelos.
I guess I just made it in the nick of time, Madam Chair.
We're happy you're here.
I raced up here. I slightly above the speed limit, but don't squeal on me. Representative Jeffrey Evangelos, House District 91, and nice to see everybody.
Thank you. Representative Newell.
Yes, thank you, Madam Chair. Good morning, everyone. I'm Rena Newell. I am the Passamaquoddy Tribal Representative.
Thank you. And next we have Representative Sheehan.
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent House District 12, that is Biddeford.
And Representative Babbage.
Yes, thank you, Madam Chair. Good morning, everyone. My name is Chris Babbage. I represent House District 8, have the privilege of representing the town of Kennebunk.
Thank you. Representative Moriarty.
Thank you, Madam Chair. Good morning to all. I'm Steve Moriarty, representing my hometown of Cumberland and part of Gray.
Thanks. And Representative Reckett.
Hello, my name is Lois Reckett, and I represent District 31, which is the ocean end of South Portland.
Thank you. And co-chair Tom Harnett.
Thank you, Madam Chair, and good morning, everyone. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, and I reside in Gardner.
Thank you. And I'm Senator Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and a little bit of Scarborough, and want to welcome everyone. At this point, just to explain the process, we'll have public hearings on two bills. That is an opportunity for us to hear from the bill sponsor and from the witnesses who are testifying in support of in opposition to, or neither for nor against the proposed legislation. It's not a time for committee discussion. That happens at our work sessions, and we will be having a work session and committee discussion following our bill hearings. And let's see, I'm going to see if the bill sponsor for our first measure is present in the attendee space. And typically how we do this for members of the public is that we will bring people who are testifying related to bills into our meeting on the panelist screen, and you'll be able to see and hear them. And then when they've completed their work, we move them back into the attendee space. And I see that our first bill sponsor is here with us today. Senator Chipman, you may introduce yourself and your bill, and welcome to the Judiciary Committee.
Great, thank you. Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Ben Chipman. I serve as State Senator for District 27, which is part of the city of Portland, and it's great to be here. I don't know if I've ever presented a bill to Judiciary before, but it's great to see all of you. I'm here to present LD 535. This is an act to provide for the well-being of companion animals upon the dissolution of marriages. Over the years, the way our society has viewed and used companion animals has drastically evolved. However, our laws have not. Current state law classifies pets based on traditional property standards, reducing companion animals to inanimate objects during divorce proceedings. I think many of us can agree that pets are quite different from our living room furniture and other items that are typically divided up in a divorce proceeding, and more factors should be taken into account when deciding where a pet should be housed after a divorce. According to a survey by the Humane Society of the United States, only 1% of Americans consider their pets mere property. Our laws should be changed to reflect the societal shift in seeing our pets as part of our families. LD 535 would require judges in legal separations and divorces to consider a pet's well-being based on specific factors similar to standards applied in child custody cases. These include the ability of a party to continue to financially support the pet, histories of animal abuse between either of the parties, and any history of domestic violence. This change in law is not novel. In 2017, Alaska became the first state to require judges in divorce cases to consider a pet's well-being, similar to standards applied in child custody cases. Other states such as Illinois, California, and New Hampshire have also followed suit. LD 535 provides reasonable and helpful criteria for judges to determine ownership of pets following a separation or divorce. I'm proud that Maine is now ranked #1 in the nation in regards to animal protection laws. Legislation like LD 535 will continue to make Maine a leader in animal welfare. So I appreciate your consideration of this bill and happy to try to answer any questions that you may have.
Thank you very much, Senator Chipman. And let's see that Representative Libby has a question. You may proceed.
Thank you, Madam Chair, and good morning, Senator Chipman. Thanks for joining us today. My question is simply, you mentioned a couple of other states that have similar legislation, and I'm just curious if your piece of legislation here is based off of model legislation from any other states, or if this is kind of more fresh and new specifically to Maine, where the origins are.
Yeah, I think it's, I've been working with a few animal advocates on this who are going to be speaking in support of the bill, Robert Fisk from Maine Friends of Animals and a few others. I believe that it is based on what has been done in some of these other states and have made a few small changes to what's being done in other states, but he could speak more specific to that. But I believe it is based primarily on what's been done in Illinois, California, New Hampshire, and Alaska.
Thank you.
Representative Reckitt.
Thank you, Madam Chair. I wondered, Senator Chipman, if you considered including horses in this bill as companion animals. I don't believe
I'm not sure how companion animals are defined, if that would include horses or not. But certainly, if it's not in the definition, it could be amended to include horses. I wouldn't be opposed to that.
Thank you. I know a lot of people whose horses are to them like my cat is to me, so.
Yeah.
All right. Thank you very much.
The point is, really just to recognize that, pets are more than just an object, and which is the current law just allows, the judges look at a pet as a piece of property, as an object, and they can't consider any other factors. So that's the point of it.
Thank you.
Representative Poirier.
Thank you, Madam Chair. Senator, are there any kind of statistics or any kind of research done that links any kind of animal abuse or neglect or anything to cases following a divorce or any kind of suit involving animals?
I'd have to look more into that and speak with some folks, but I'm happy to do that and see if we can get some more information for you between now and the work session.
Okay,
I don't have any information off the top of my head about that, but I'm sure there is some that we could find.
Thank you, Representative Poirier. And Representative Evangelos.
Thank you, Madam Chair. Hi, Ben.
How are you?
I'm doing good. Nice to see you. And Madam Chair, I don't have a question, but Ben and I did a lot of work together in the House, and I miss seeing him. So I just wanted to say hi.
It's good to see you too.
Thanks.
Yeah.
I don't see any more questions at this time. So thank you very much, Senator Chipman. And I understand that you have a co-sponsor here to testify, and then you were wishing to have Mr. Altshuler testify. Is that correct?
Yeah, if we could, because Mr. Altshuler is a divorce family law attorney who has, I believe, some kind of court proceeding at 10:40 that he's got to be in. So we're hoping that he can speak after any co-sponsors so that he can be finished and get to the court proceeding he has to be to.
Okay, I am not seeing any co-sponsors in the attendee space. Oh, here we go. That's because she was traveling through cyberspace. Welcome, Representative Dodge. It's nice to see you.
Carney.
Would you like to proceed with your testimony?
I absolutely would. Thank you very much. Good morning, Senator Carney, Representative Harnett, and esteemed members of the Judiciary Committee. My name is Representative Jan Dodge of House District 97, which includes Belfast, Northport, and Waldo. I'm here to testify in strong support of LD 535, an act to provide for the well-being, of companion animals in the dissolution of marriages. The physical safety of pets is worthy of protections. It is evident that most owners acknowledge and accept all that is included in providing for their pets' physical needs. That safeguard is also afforded in Maine law, Title 19A, that includes protection from domestic violence. The emotional attachment between pets and their owners is usually a strong one. Almost everywhere in our society, you can see dogs who are faithful running partners and cats or dogs who join other family members for the annual Christmas card picture. Perhaps you are acquainted with or are yourself a pet parent. Some of us have no human children, but consider ourselves moms or dads to the animals in our households. Animals form relationships with their owners and handlers. These can be observed in the duty accepted by seeing eye dogs, canines used to find explosive devices, emotional support animals, and those trained to guard and protect their owners. Acknowledging the loyalty, dedication, and love that these animals display illustrates that pets deserve the emotional safety and protection of LD 535, including criteria and guidance to help determine what would best provide for a pet's physical and emotional needs is important in accomplishing the bill's intent. Thank you for your work today to protect pets and those who love them during the process of divorce. I will try to answer any questions you may have. Thank you.
Thank you, Representative Dodge. Are there questions on the part of committee members? Not seeing anyone. Any questions? Thank you so much for speaking with us today.
Thank you. Great to see you all.
You will travel back through cyberspace.
I will attempt to.
And then the next person speaking in favor of this matter is going to be Attorney Altshuler, and I am going to see if I can have him join us. Soupy, I'm not a co-host, so I'm not able to move people through cyberspace. Up there we go. Thank you very much. And Mr. Altshuler, when you are here, you can activate your video and audio and proceed.
Sorry. Am I visible now?
Thank you, and welcome to the Committee on the Judiciary.
Thank you, Senator Carney and Representative Harnett, and of course, the members of the Judiciary Committee. And thank you for accommodating my need to attend a hearing later this morning. And more importantly, allowing me to speak in favor of the passage of LD 535. In 2012, I was honored to be elected president of the American Academy of Matrimonial Lawyers. It's a national organization of 1,700 lawyers, as well as being a manager of the International Academy of Family Lawyers. And I can assure the committee that this topic is one of great significance to most lawyers nationally and internationally, and almost across the board they support the view that pets must be more than chattel. In my 36 years of family law practice, I've encountered virtually every issue imaginable pertinent to the dissolution of a marriage. And although we know there's no issue more heart-wrenching than the parental rights and responsibilities of a child, I will say that the award of a pet is certainly a close second. As we know, by law today, pets are defined as chattel with equal standing to living room furniture, coffee makers, and a toaster oven. But as anyone who has a pet knows, a pet is a living being deserving much greater consideration than one person getting the lamp in the library and the other the living room easy chair. To not provide the courts with the ability to determine what is best for that pet and the owners of that pet based upon more evidence than simply who paid for it is short-sighted and ironically is inhumane. And to assert that judges can already consider other factors is simply incorrect. The law is clear that as chattel, a pet cannot be shared, and whomever can prove ownership of this property, which is typically, I paid for it, gets the pet. No other considerations are allowed. And I will add that the argument that allowing judges to consider other factors when determining the disposition of a pet would be further burdensome on court time is simply spurious. As someone who has participated in hundreds, if not thousands, of contested hearings, I can tell you that I could easily have a client outline for a judge his or her response to the factors being proposed in this legislation in less than 30 minutes. It will not add court time. It will not be burdensome on the judges. As the legislature well knows, it is important to recognize that in an abusive situation, a spouse will use a pet to further his or her power and control over his or her spouse, as well as to further abuse or intimidate his or her partner. I can tell you from firsthand experience, I've been in situations in which an individual has no interest whatsoever in retaining possession of a pet, but because he or she paid for the pet and he or she knows how important that pet is to the other spouse, that individual will advocate for ownership just to exert more power over and abuse to that spouse. The legislature has been great in the state of Maine recognizing abuse and power control in marriages and having pets included in situations like protection from abuse, and applauding the state of Maine for this foresight. For all these reasons, plus others too numerous to detail in this short period of time, I strongly support and urge you to pass LD 535. Thank you for consideration. I have very little time, but if anybody has a question, I'm happy to answer it.
Thank you very much. Are there questions on the part of committee members? Representative Moriarty?
Thank you, Madam Chair. Good morning, Mr. Altshuler.
Good morning, Senator, Representative.
Good to see you again. I just wanted to double check with you on one point. Are you saying that currently, under current law, judges do not have any discretion at all to weigh matters of emotional attachment and so forth in the disposition, sort of a tough word, but the disposition of a pet? They can only consider traditional indicia of ownership, such as purchase?
That is correct. I've had 3 hearings on pets in the last 2 years. One was not a marriage situation, but the other 2 were. And it was very clear, and both the 2 judges, or very knowledgeable judges, said, pets are chattel. I can only consider who owns it. I can't share it. I can't give visitation rights. And the indicia is, generally speaking, who paid for it. Sometimes you have 2 people on the bill of sale. Sometimes you have the person who wrote the check or paid the credit card. But yes, under Maine law, ownership, whoever the court determines owns the pet, gets the pet without any other factors being considered. 0.
Oh, all right, so here's a follow-up. Suppose the pet was acquired during the marriage. It is presumably then marital property and jointly owned during the course of the marriage. So in that context, does the purchase of the animal make any difference if it's marital property?
Well, it does, because if you think about how personal property gets divided, and I had a hearing, by the way, on a toaster oven, so I know personal property disputes. Judges have to decide, for example, who has a better claim on that toaster oven. And typically it's who paid for it, who wrote the check for it, who's on the bill of sale. So marital property can be divided, but even in personal property issues, the judge has to decide who has a better claim for it. Was it a gift from a family member? Was it purchased by the brother of a spouse? So yes, the court can only give it to one person, and the court has to decide who has a better claim based on purchase and ownership, no other factors.
Thank you.
Thank you very much. Committee, well, first of all, Mr. Altshuler, do you have time for one more question if there is
I
another?
have as much time as you need, Your Honor. Thank you.
I'm not seeing any other questions, so thank you very much for being with us today.
Thank you very much. And thanks again for accommodating my need to leave early. I appreciate it.
You're welcome. Okay, at this point, I'm turning to those who are in the attendee space and asking for everyone in the attendee space who is here to testify in support of LD 535, an act to provide for the well-being of companion animals, to raise their electronic hand, and please keep your electronic hand raised because that's the only way I'll know to pull you into the panel. Okay, so I see two folks, and then we have Beth Galley is already in the panel. Ms. Galley, are you here to testify in support of this legislation? Okay, that's a little.
I am. Can you hear me?
Yes. Are you here to testify in support of LD 535?
Yes, I am.
Great. Then you will be the next speaker. Thank you very much. You can proceed. And please activate your video as well.
I have an old set, and so all you get is my picture. I'm sorry.
That's fine. That's fine. If it's a technical issue, you can go proceed at this point then. And we do have a 3-minute testimony limit, so I'll let you know when we're close to that. Go ahead.
Well, I'll answer the questions that have been asked. One is, does this resemble other legislation in the 4 other states who have such a bill? And our bill is different in 2 ways. One is that we specify the factors that a judge may consider when deciding who should have custody of the pet. And the other bills just say that they allow for the judge to consider the well-being of the pet. And they're very simple. They're a simple sentence, but we decided we needed to spell out more, and we did. And the second thing is the 3 states allow for joint custody. California, Alaska, and Illinois speak of joint custody. Our bill, the state of Maine, the one that's being proposed, does not provide for joint custody. It only provides for, it doesn't mention it like New Hampshire's bill. So in fact, our bill is more modest than the 3 other bills. And it is also more detailed, and it tells exactly what factors the judge should consider. And they're based on the idea that the person who has a history of loving and caring for the animal is probably the well-being of the animal would be enhanced by giving that person custody of the animal. So it's based on past history, going forward, what the most likely result. And then the other question was, would a horse be in? And if you considered companion animal, and under our definition, it's for the purpose of this subsection, companion animal means an animal kept primarily for companionship rather than as a working animal, service animal, or farm animal kept for profit. So a horse would be maybe a farm animal, but if it's your companion animal when you're riding and it's clearly a pet, then it would be included. What horse may not be included could be a very valuable stud horse, or maybe a draft horse, or a horse that is used to pull people around at Christmas time. That's part of a business.
Thank you very much, Ms. Galley. Are there any questions among committee members? I'm not seeing any. Thank you. We appreciate you being here today.
Thank you.
Next we'll Katie Hansberry is joining us now. And as soon as you're present and unmuted, go ahead, you can begin your testimony.
Thank you so much. Good morning, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. My name is Katie Hansberry, and I'm the Maine State Director for the Humane Society of the United States, and written testimony from HSUS has been submitted jointly with the Animal Legal Defense Fund. I'm here speaking to you today in my capacity as the current president of the Maine Federation of Humane Societies, a collaborative statewide network of humane organizations working to support animal welfare groups, promote the adoption of homeless animals and responsible pet ownership, and to end pet overpopulation and animal cruelty through education, outreach, and advocacy. Our mission is to provide resources and opportunities dedicated to promoting and advancing the humane care of all animals throughout the state of Maine. I want to thank Senator Chipman for sponsoring the bill, as well as all the co-sponsors, and respectfully urge you to vote ought to pass on LD 535, as it would provide important clarity by ensuring Maine courts consider the best interests of a pet during divorce or separation proceedings. Maine's animal shelters too often see instances in which people in the middle of a divorce or separation use family pets as leverage and/or to hurt their spouse. For example, one party will surrender a pet, and then the shelter receives a frantic call from the other party looking to reclaim their beloved pet. One of the main reasons Alaska passed the first law regarding pets in divorce was because perpetrators of domestic violence tend to have pets in their name, vet records, dog licenses, etc., making it difficult to prove that a survivor should be the final owner of the animals in those divorce separations. Unfortunately, Maine has a significant incidence of domestic abuse, with the Maine Department of Public Safety reporting in 2018 that a domestic violence assault is reported to law enforcement every 2 hours and 22 minutes. It is important to note that many domestic violence assaults are not reported, and that is only one form of abuse. Just because a court may have the discretion to take something into consideration doesn't mean they will. Given the important role pets play as part of our families and how they can be utilized as a means of control in an abusive relationship, it isn't enough to know that a court may take additional factors regarding a pet's best interest into consideration. Rather, parties to a divorce or separation proceeding should have the assurance that the court will look at much more than a signature on an adoption agreement or a purchase contract. And this wouldn't be the first time Maine acknowledged the special status of pets and the importance of doing so in family law, as Maine led the way in 2006 by enacting the first statute that specifically allowed judges to include pets in protection from abuse orders, and then reaffirmed that by amending the law in 2013 to importantly clarify it included temporary protection from abuse orders. Especially as a state leading the nation in animal protection laws, Maine should pass LD 535. Thank you very much for your time and the opportunity to testify.
Thank you for testifying this morning, Ms. Hansberry. Committee members, does anyone have a question for Ms. Hansberry? Not seeing any hands raised. Thank you very much.
Thank you.
For coming today. And our next speaker is about to join us, and that will be Robert Fisk. Mr. Fisk, oh, there you are. And you are, whoops. You are muted, Mr. Fisk. If you can unmute yourself, please.
You good?
There we go.
Thank you. Sorry about that.
That's all right. Welcome to the Judiciary Committee. You can proceed.
Good morning. It's nice to be with you. Before I give my testimony, I did want to note that the bill had a fact sheet, which I hope to attach to my testimony, and I apologize it wasn't, but I will send along to the clerk, and hopefully it will be useful and helpful in reviewing the bill. Sure. And I would like just to quickly take the moment and the opportunity to thank Senator Chipman for sponsoring this legislation, as well as his longtime commitment to animal protection. It's very much appreciated. Okay, well, given the 3-minute rule, I will read my testimony as well. Good morning, Senator Carney, Representative Harnett, and distinguished members of the committee. My name is Robert Fisk. I am from Falmouth and President and Executive Director of Maine Friends of Animals, speaking in support of LD 535. In 1897, the Supreme Court ruled that citizen-owned dogs were personal property However, animals were far less understood at that time. Dogs in particular were kept primarily to make money for their owners through labor or breeding until transformation from a mostly rural society to an urban society. We changed working animals to our companions. Now, over a century later, it's undeniable that Americans view sentient beings, especially companion animals, much differently. We as a society have become increasingly uncomfortable trying to reconcile how we treat other species, particularly the inconsistency of family pets legally being considered property, no more, no less than a chair or a toaster. Ultimately, there needs to be another classification to reconcile this obvious void. Yet we already see the issue manifest itself in divorce proceedings. Divorce attorneys say that pet custody and care issues are becoming more common as state courts confront divorce laws that fail to recognize that not every crucial bond is between humans. As brought up, the Humane Society survey had that only 1% of Americans considered their pets mere property, and today 80% of their owners view their pets as family members. Maine state law provides no special provisions for pets in which marriage dissolution is based on traditional property classifications, reducing them to inanimate objects during divorce proceedings. This bill will have the unique authority to assist judges in determining a companion animal's interest when considering its future in custody. Current statutes provide no specific direction to judges regarding factors to consider in doing so. This legislation provides reasonable and helpful criteria when evaluating the companion animal's well-being, and they're enumerated in the bill. This bill is not a radical departure from the current law. Maine's Title 19A domestic relations already treats animals differently from mere property by allowing judges to include companion animals in domestic violence protection orders, as do many other states. In concluding, Alaska, Illinois, California, and New Hampshire have already passed laws allowing judges to decide the ownership of a dog by taking in consideration, quote, the well-being of the companion animal, unquote, or, quote, the care of the pet animal, unquote. Other states are considering or pursuing similar legislation. As previous speaker, thank you, I'm last sentence. As previous speaker, Attorney Altshuler pointed out, that judges view pets more akin to children than dining room sets and recognize that people have an emotional attachment to their animals. I urge the committee to vote to pass on LD 535, and I'd be happy to try to answer the questions the committee may have.
Thank you very much, Mr. Fisk. Committee members, does anyone have questions for Mr. Fisk? Not seeing any questions. Thank you so much for being here and presenting your testimony this morning.
Senator, may I just make a quick moment? There's a number of really good written testimony by divorce attorneys, and if obviously if you get a chance, I think they'd be very helpful in reviewing the bill.
And that's all been submitted to us already.
It is, but I just want to point out there's a lot of good testimony from divorce attorneys in the written testimony.
Great. Thank you for pointing that out to us. We appreciate that. Okay, and then the next person here to testify in favor looks like is Julia Finn.
I'm neither for nor against, I believe. I don't know if you want to wait, save me for later.
Yeah, you can stay in the panel, but just stay muted and with your video off, and let me pull in the next. Catherine Savarell, who's in the participant list. I believe that you're here to testify in support, so I'm going to move you into the panel.
I'm actually here to testify in opposition, so
okay.
I don't know if you want.
All right, so why don't you just stay where you are in cyberspace for a moment, and let me turn to the attendee group in general and ask now if there's anybody in the attendee space who is here to testify in favor of LD 535. Please raise your hand. And I'm not seeing anybody who still remains to testify in favor. So now we'll take those who are here to testify in opposition. And we know that Ms. Savarel is, but if anybody else in the attendee space is here to testify in opposition, please raise your electronic hand and keep it raised until we call on you. And Ms. Savarel, you may activate your video and audio and proceed. Welcome.
Thank you. Thank you, Senator Carney, Representative Harnett, and members of the Judiciary Committee. My name is Catherine Savril, and I'm the Executive Director of the Maine Veterinary Medical Association. As a representative of the Maine Veterinary Medical Association, I'm testifying in opposition of LD 535. We hesitate to speak against the good intentions of this bill in trying to address the needs of companion animals in a divorce, but we do have some concerns about potential consequences of this bill. One of our concerns regards what appears to be a broad definition of companion animal. The last sentence in the bill for the purpose reads, for the purposes of this subsection, companion animal means an animal kept primarily for companionship rather than as a working animal, service animal, or farm animal kept for profit. Which may be troublesome. Title 7, Chapter 717, subsection 3907 defines companion animal as a cat or a dog. So this bill would create confusion about the definition of a companion animal versus livestock. Livestock is distinctly defined in Maine law, and this bill blurs that distinction. In addition, it would likely be difficult to apply such a law to animals outside of dogs and cats. While the bill maintains that animals are property and their disposition falls under the subsection that covers property, the introduction of the well-being of the animal could be interpreted to imbue animals with a special separate status from other property, which can have far-reaching effects. A similar bill, as was mentioned, was passed in California in 2019. And if this committee decides to move forward with this bill, we recommend a similar change as was made to that bill before it was passed. And the change that was made was that the court was authorized to consider these factors, but not that it was mandatory. A potential introductory sentence might read, in the disposition of property pursuant to subsection 1, the court, when requested by a party, may consider the following factors in determining the final ownership of the companion animals. And in our testimony, we did link to the California bill for your reference. Since the domestication of animals, how we feel about our animals has always seemed to be at odds with how we legally define them. The law has a responsibility to animals and animal owners to not permit feelings to overrule common sense. When we endeavor to codify in statute the love we feel for the animals with whom we share our homes and lives, we can threaten the welfare of the very animals we've set up to protect. Joint custody for an animal can create additional behavioral problems for that animal, and training becomes more difficult due to a potential lack of consistent routine between homes. Adequate care can have a broad interpretation and meaning beyond the statutory language. Is it providing all recommended preventative care? Is it only rabies vaccines? Is it spinal surgery if a dog develops a herniated disc? Who is monitoring and evaluating outcomes or results for the companion animal? And one final concern specifically involves the practicing veterinarian. If joint ownership is decided, who makes a euthanasia decision? The veterinarian needs to believe that the client bringing the patient in is the owner, unless the client says otherwise. What if the animal, based on a court order, was technically owned by the other? As a veterinarian, we would have no way of knowing this, and we wonder if the individual making the recommended euthanasia decision would be at risk for a civil suit, or would that veterinarian be at risk? Finally, we agree that the ownership of an animal and care of that animal should be a high priority for any marriage dissolution, second to the needs of the care of any children in the home. However, is this determination based on the well-being of the companion animal, the job of the court system? Thank you, and I'm happy to take any questions.
Thank you very much. I see that we have one question for you. Representative Libby, you can proceed.
Thank you, Madam Chair, and thank you for being here, Ms. Several. My question stems with wondering just is your primary, it sounds like your primary reason for not supporting the bill is having an issue with joint custody. Is that correct?
I think that we feel that going down this road of giving additional rights to animals brings up a lot of complicated questions around how care is delivered and how those decisions are made. But joint custody would be a major concern and could create a lot of confusion.
So Ms. Galley had testified that LD 535 would not provide for joint custody of the animals. Would that address your concern?
You know, I'm not sure. My reading of it wasn't clear that it would certainly not would be precluded, but that would help address our concerns along with the definition of companion animals.
Thank you.
Other questions by committee members? I'm not seeing any. Thank you very much for appearing and presenting your testimony today, Ms. Savarol.
Thank you.
And I think we've heard from all of the opponents. For those in the attendee space, is there anyone who wishes to testify in opposition? If so, please raise your electronic hand. All right, I'm not seeing any, and so we'll welcome Ms. Finn to testify neither for nor against.
Thank you, and good morning. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Julie Finn, and I represent the judicial branch. I would like to present some additional information on this bill. LD 535 requires the court to consider multiple factors in family cases in which the homing of a family pet is under dispute. These factors include the needs of the animal, the amount of time each party has spent with the animal, the ability of a party to financially support and care for the animal, the emotional attachment of a party to the animal, the emotional attachment of a child or children to the animal, and any domestic violence or animal abuse that may have occurred in the household. Unsurprisingly, disputes regarding family pets are currently being addressed by the courts. Evidence is submitted and judges rule accordingly. If there is a problem with the current means of addressing these issues, until this morning, we had not heard about it. Judges are well aware of the emotional attachment between people and their pets and the possibility that parties will exploit this attachment to gain an advantage in a family case, particularly in domestic violence cases or cases in which a protective order has been granted. In fact, our form Protection from Abuse complaint makes specific reference to animals. A plaintiff may check a box and request possession of property, including pets, and may also request that the court order the defendant not to injure or threaten to injure any animals. If the judge grants this request, it is part of a court order. If this law were to pass, it would burden the already overburdened courts. The specific factors listed in the legislation would require and generate significant additional evidence, both documentary and testimonial, to possibly include the testimony of professional expert witnesses. Because the language indicates that the court shall consider all relevant factors, the court would be compelled in many instances to schedule additional hearing time to allow for this evidence. Given the court's current pending caseloads due to the COVID-19 pandemic, the timing for proposing these new requirements is of concern. As you know, we have 8 family law magistrates who work exclusively on family cases. They help families resolve disputes about childcare, education, child support, and child contact and visitation. Given that the pandemic has ended or changed parents' jobs in many instances, closed daycare centers, turned parents into remote ed techs and teachers, and illuminated differences among individuals about how to respond to the pandemic, you would correctly understand that the magistrates have had even more work during this past year than they had before. And our district court judges, who usually cover both family and non-family dockets, have been spending most of their time on family cases because the disputes have either been caused or exacerbated by the pandemic. There are not enough hours in the day to get the work done as it is. We all love our companion animals. The courts already addressed requests for custody of these animals. Requiring additional analysis will increase the workload and the time necessary for hearing, further delaying all family cases. Thank you, and I'd be happy to answer any questions you might have.
Thank you very much. Committee members, are there any questions? Representative Moriarty, go ahead. Steve, you are still muted.
Thank you. Ms. Finn, looking just at the divorce situation and not protection from abuse, and assuming the pet is marital property, what standards, in fact, are applied by the judges now?
Assuming the pet is marital property, then the judge really has broad discretion in that scenario. In Title 19, they're able to consider all relevant factors. That's not very specific, but it does give the judge wide latitude and discretion to consider different types of evidence with respect to a family pet.
But I take it it's not, the standards are not articulated as they are in the banner of the bill.
That's correct. Although no, the statute doesn't articulate the standards, but judges frequently consider things like how and when the pet was acquired, who cares for the pet, and other reasons why each or both parties think that the pet should reside with them.
Okay, thank you.
Thank you very much. Representative Libby, go ahead with your question.
Thank you, Madam Chair. Thank you for being here today, Ms. Finn. My question is, would you feel any differently if the, either for or against, if the language was may consider rather than shall consider?
I hadn't thought of that before today, and I noticed that I think it was Dr. Sovril brought that up, and that would certainly improve the bill if the factors weren't mandatory from the judicial branch's perspective.
Thank you.
Not seeing any other questions. Thank you very much for providing testimony this morning, Ms. Finn.
Thank you.
And I believe that we've heard from everybody who is here to testify on LD 535. If that's not the case, please raise your electronic hand. Not seeing any hands. Thank you very much, Senator Chipman, for presenting your bill this morning.
Thank you.
And that takes us to our next matter. First, the public hearing on LD 535 is now closed. We will open the public hearing on LD 579, which is a resolve to conduct an independent examination of the protection order system to determine whether there is systemic misuse by applicants. And Representative Hanley is here today to present this bill, and you may proceed, Representative Hanley. Welcome to the Committee on the Judiciary.
Good morning. Thank you, Senator. Can you hear me okay with this shield on? Is my audio okay? Good. Thank you. All right. Thank you. I'm Jeff Hanley, State Representative for District 87, which is Alma, Pittston, Wiscasset, and Randolph. And I'm here to introduce this resolve, which is LD 579. And a resolve to conduct an independent examination of protection order system to determine whether there is systemic misuse by applicants. We as legislators, whether we're in the Senate or the House, we run our campaigns, we get elected, and we enter into these chambers with the intention of creating good law. That the things that we do, whether we putting limits on things or taking limits off things, or forbidding or permitting spending money or saving, all the things that we do, we always try to do what is correct and right. So, but occasionally we might actually put into law that some things that maybe aren't working properly. And if we do, we owe it to ourselves and our citizens to take a bit of a look back at what we've done. And that is the purpose of this resolve. It simply asks that a commission be formed and ask for input from all over the community about the effects of the protection from abuse order system. Because the intent of that, the PFA system is naturally for domestic abuse and a very necessary part of our judicial system. But after talking to some of my constituents, there's some information that would lead to believe that maybe this law has been formulated in such a way that it might be used actually as a form of, instead of judgment, it becomes a form of almost abuse. In a reverse way, it becomes a harassment of people. And instead of delivering justice, it might do just the opposite. So I think it's worth a study, worth a few questions being asked, and to make sure that it's not abused and that people that are subject to it aren't harassed themselves needlessly. So that, again, that's the conclusion of my testimony, and I'll try to answer any questions.
Thank you very much, Representative Hanley. I'm turning to committee members to see if anyone has a question for the bill sponsor. I'm not seeing any hands. Thank you very much for presenting your bill today, Representative Hanley.
Thank you very much.
And at this point, I will turn to those in the attendee space and see if there is anyone in the attendee space who's here to testify in support of this legislation. Please raise your electronic hand. Not seeing anybody in support, and anyone in opposition. And I believe that Andrea Mancuso has already joined us on the panel, and so you may activate your camera and audio and present. Thank you very much, Ms. Mancuso.
Thanks, Senator Carney. I'm speaking neither for nor against. Just wanted to clarify that if you still want me to start.
Hang on for just one moment and let me just clarify that there's nobody here in support or opposition. And turning to those in the attendee space, is there anybody here in support of this measure? Not seeing any hands. And against? Also not seeing any hands. So now we are at neither for nor against, and you may proceed.
Thank you. Good morning, Senator Carney, Representative Harnett, distinguished members of the Judiciary Committee. My name is Andrea Mancuso. I'm here today on behalf of the Maine Coalition to End Domestic Violence. We've submitted extensive written testimony in response to this bill, and I hope you have a chance to read that in its entirety as you make decisions on next steps. I'd like to spend the majority of my limited time with you this morning providing some context. In 2020, 5,200 complaints for protection from abuse orders were filed in Maine's district courts. Of those, 4,600 temporary orders were issued, and roughly 2,300 final orders were issued. So 2,300 is the number we're talking about. During that same time period, more than 12,000 survivors of domestic abuse and violence in Maine reached out for help through Maine's domestic violence resource centers. And we know this is not reflective of the total need, as many survivors don't or can't reach out. Additionally, there are approximately 4,000 defendants charged each year in our criminal courts with having committed crimes against family or household members. On average, across the lifespan, we know that only about half of survivors will reach out for criminal justice system intervention. Domestic violence is a real problem here in Maine, as it is across the country. And as this data reflects, our courts see only the tip of the iceberg. Given the role domestic abuse and violence play as a driver of crime and homicide in our state, we must reach for more safety and support for survivors and their children, and not spend what precious time and resources we have giving space to those who have used abuse and violence to air their misplaced grievances. The suggestion of the proposal that there is systemic misuse by applicants is not supported in the experiences of those professionals that work within this system, some of whom you'll hear from today, and importantly, from Maine's judicial officers. The suggestion that the process unfairly holds to account those who have chosen to perpetrate abuse and violence against their family and that somehow a violation of a protection order should not result in real consequence to the person who has chosen not to cease their destructive behavior because it is not in the form of a new assault, reflect philosophical disagreement with the legislative policies created in response to domestic abuse and violence in Maine, and not misuse of those processes by the applicants in practice. This bill in its current form proposes a study that is unlikely to reveal any new and valuable information and is unworthy of support by the Maine legislature. We would enthusiastically welcome a study on the impact of our justice system responses on families that experience domestic abuse and violence, if the methodology and the goals are appropriately articulated. In written testimony, you'll find some broad questions that we think the committee would be wise to want to know the answers to. And I would note that any study that could provide valuable insight into these questions would require substantially more time than is currently proposed and would need to be funded so that the Abuse Commission could contract a research institution with expertise in qualitative data analysis across systems. Finally, I would just note that there is no want of information already available to the committee about steps that could be taken right now by the legislature to enhance Maine's civil justice response to domestic abuse and violence. Several multidisciplinary reports issued here in Maine over the last few decades speak to those recommendations. Some of them are noted in our written testimony. I believe I'm out of time, but I'm happy to answer any questions.
Thank you very much. You do have about 3 more seconds if there's anything you wanted to say in conclusion.
Happy to take questions.
Thank you very much. Committee members, are there questions for Ms. Mancuso? I'm not seeing any questions for you. Thank you for providing your testimony this morning.
Thank you. Nice to see you all.
For those who are in the attendee space, if you wish to testify neither for nor against LD 579, please raise your electronic hand. Okay, Julia Finn is, oh, all right, I see that Ms. Lucia Hunt has joined. Ms. Hunt, you may proceed with your testimony. Welcome to the Committee on the Judiciary.
Thank you, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. My name is Lucia Hunt, and I'm the chair of the commission.
We are having a very hard time hearing you. I don't know if there's something malfunctioning with your microphone. Could you please start again?
Certainly. Is that any better? I know we have a fan issue with my computer. I'm getting fixed this afternoon. Is that better? A little bit?
No.
Oh, great.
Yes.
My apologies. Good morning, Senator Carney, Representative Harnett, and members of the Committee on Judiciary. My name is Lucia Hunt, and I'm here today speaking on behalf of the Commission on Domestic and Sexual Abuse, neither for nor against LD 579. The Commission is comprised of a wide group of professionals who focus on issues of domestic violence and sexual abuse, and the Commission is tasked with advising and assisting the executive, legislative, and judicial branches of state government on issues related to domestic and sexual abuse. The Commission would be an appropriate entity for a study such as the one that's been proposed. We are created within the Protection from Abuse statute, and we believe strongly that the protection from abuse process is an important component of a coordinated community response to domestic violence and can be an essential part of a safety plan for survivors. Additionally, more data about the PFA process would be or could be very valuable. However, in our discussions related to the proposal in front of us, this resolve, Commission members had several concerns and considerations that I'd like to bring to your attention. First, misuse of the protection order system is not an identified priority, either for members of the Commission who do this work frequently, or in any of the many, as Ms. Mancuso referenced, existing reports about domestic abuse by the Commission itself, the Homicide Review Panel, previous gubernatorial commissions directly related to domestic violence. It hasn't risen to the level currently or in any of those reports of a priority for study. The issue of whether there is systemic misuse specifically just isn't a pressing need. Additionally, Commission members conclude that the existing statutory protections within the Protection from Abuse and Family Matters statutes and the judicial process itself are adequate to address any misuse when it does occur. Judges are well equipped to use their judicial discretion in each individual case to address the unique facts and circumstances presented at trial. And they do that, although it's a expedited process and a protection order. Initially, the temporary order can be granted on an ex parte basis. Final orders are fully adjudicated through a trial process, and judges, in my experience, use significant judicial discretion in deciding which cases go forward and what relief is granted. Additionally, the litigants would have a right to appeal a court's decision, and the issues of parental rights and responsibilities are required by our existing statutory scheme to be determined de novo in any subsequent family matter case. There was a similar study conducted and reported actually to the 124th legislature in 2010. One of the questions that was asked in that study was whether misuse of the PFA process is happening. There was also consideration about the laws around domestic violence and parental rights when domestic violence was present. That report concluded that there was not widespread misuse of the protection from abuse process, although the process was sometimes used as a substitute for emergency family matters or to address child abuse or neglect. I would say, having recently reread this report, many of the same issues exist today, and our statutory scheme has not changed substantially, even though it was in 2010 that this report came out. There was a substantial effort by the Abuse Commission to produce that report. We are an unfunded commission, and MCEDP commission members, many interns were used to compile surveys, research from other states, victim input, focus groups, and that report also came out with numerous recommendations. Some of those recommendations have been addressed, some of them are underway, but there are many that continue to be unaddressed. If this committee charges the Abuse Commission with studying the misuse of the PFA process and the laws and practices governing parental rights and domestic abuse, they should also consider those existing recommendations.
Your 3 minutes is up, and there may be questions from committee members. So I'm sorry to interrupt you, but let me turn to committee members and see if anyone has a question. Representative Harnett, did I see your physical hand? No. Not seeing any questions by committee members. I would just ask you if you could please provide us with a concluding sentence or two in light of the fact that there are no questions.
Thank you. An effective study on these issues would require adequate time and resources in order to produce quality results. And if the committee does decide that the Abuse Commission should review and study these issues, we would respectfully request an ability to provide some input on the questions presented and adequate time and resources, including, for example, a research institution study by someone like the Muskie School in order to conduct an effective study of these issues.
Thank you very much. We appreciate your appearing before the committee this morning. And I will turn to, I see that there are a couple of other people here to testify neither for nor against. And we'll move, Julie Finn is coming over into the panel space. And Ms. Finn, you can go ahead and proceed when you are ready.
Hi, thank you very much. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. I am Julie Finn and I represent the judicial branch. This resolve proposes that the Maine Commission on Domestic and Sexual Abuse study the Protection from Abuse order system to determine whether there is systemic misuse by applicants. While there may be good reasons to study the laws and practices governing parental rights when a domestic abuse is asserted, the bill raises many questions with respect to its methods and goals. Some of the language used in this resolve is difficult to interpret. Terms such as systemic misuse and de minimis violations or orders are not defined and require a subjective assessment. For example, how would the commission determine if misuse had occurred? Does misuse mean that a plaintiff has not been truthful? An examination of the file and the evidence is unlikely to reveal nefarious intent or untruthfulness. The concept of fairness is raised more than once in the resolve. Of course, fairness and justice are the goals of every court case in every order. The due process ensured by both the United States and Maine constitutions and utilized by the courts provides fairness in terms of procedure. Parties to a case who are concerned about the outcome of that case have an absolute right to appeal the grant or denial of a protection from abuse order, and that appeal goes to the Supreme Judicial Court, sitting as the law court. In addition, how would the commission determine what is fair and what is not fair in terms of results? The question of whether something was fair or unfair is typically a very subjective analysis. If this resolve were to become law, the judicial branch would make relevant non-confidential files available for review to assist the commission, and the commission could order transcripts of any hearings that it wished to look at. An analysis of the paper files, transcripts, and other evidence, which would be time-consuming, would have to be undertaken by commission members or staff. And as stated earlier, the plaintiff's intent is unlikely to be apparent even upon review of all the file documents. Finally, although the judicial branch is listed as a participant in this study, we must politely decline to be involved. Decisions and orders issued by district court judges presiding over protection from abuse actions are reviewable by the Supreme Judicial Court, sitting as the law court, only when one of the parties to an action has filed an appeal. Thank you very much for your time, and I'd be happy to answer any questions.
Thank you very much, Ms. Finn. Committee members, are there questions for Ms. Finn? Not seeing any. Thanks for your testimony this morning.
Thank you.
Brings us to, I think, our final person wishing to speak neither for nor against on this bill, and that's Melissa Martin, who's will appear on the panel in just a moment. Good morning, Ms. Martin. You may proceed when you're ready, and welcome to the Judiciary Committee.
Thank you, and good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. I am Melissa Martin. I am here speaking on behalf of the Family Law Advisory Commission, neither for nor against LD 579. Essentially, FLAC supports the Abuse Commission's testimony and point of view on this bill. It is not, in FLAC's opinion is that it is not a priority to conduct another study at this time, but that if another study is conducted, it would be important that that study is carefully constructed and appropriately funded and allows for valuable input from partners such as the Muskie School to allow that study to be appropriately done. I'm happy to take any questions at this time.
Thank you very much, Ms. Martin. Committee members, does anyone have a question for Ms. Martin? I am not seeing any questions, so we appreciate you providing your testimony today. And Representative Harnett, did you have a question? No. Okay. We have a little miscommunication because his electronic hand doesn't work, so I'm always looking for hand signals. All right. Thank you very much, Ms. Martin. And just one last check-in with those in the attendee space. Is there anyone present who wished to testify in any capacity related to LD 579? If so, please raise your electronic hand. I'm not seeing anyone, so that concludes the public hearing on LD 579. And at this point, next on the committee's agenda is our work session on the biennial budget. And I would suggest to committee members that we take maybe a 5-minute break. Does that seem good to everybody? Seeing some nodding heads. So let's give ourselves 7 minutes. Let's reappear at 11:20. And please, during the break, mute your audio and turn off your cameras. because the live stream continues. Thank you. committee members, I'm just checking in with everyone to see if you're able to rejoin the meeting at this point. Give everybody just a couple more minutes. All righty, it looks like the committee has returned. And the next, we have a couple of items on our agenda this morning. And one is the Maine Commission on Indigent Legal Services budget. And the other is Part KK that we began to discuss last week. And then I think we were a little tired and a little confused about that issue. And so we postponed it till this week. Peggy, I think that maybe what it would make sense to do, since KK is such a discrete little piece of the work that we need to do today, if we could take that first. Does that seem like a good plan to you?
Sure. The other piece you haven't done is Part FFF, but that's related to MCILS. That's their rulemaking authority. So it makes sense to get KK out of the way, I think.
Okay. So committee members, I'll draw your attention to Part KK. And if you don't have it at your fingertips, I'm happy to screen share it. So just kind of wave your hand if you would like me to screen share it. Looks like that is kind of a popular idea. So with a little patience from all of you, let me go ahead and screen share it. Okay, so it's the last item, next to last item. So Peggy, do you want to give us a little reminder of the of this issue, and then
Sure.
we take a vote on it?
Yes, and I apologize. I probably made it way too complicated last week when we were talking about this. Current law requires the state to purchase a bond when it's acting as the public conservator or the public guardian. And the law court has determined that the state is not liable to anybody who would be injured or has any kind of damages resulting from the actions of the public guardian or the public conservator, because the Tort Claims Act provides immunity. So the idea is to save a little bit of money, it's $14,000, and take out that statutory language that requires the state to purchase a bond. Other conservators might be required to post a bond. It's up to the probate court to determine if a bond needs to be posted in private conservator or private guardianship cases. So this amends the law in 18C, the probate code, to in several places to take out any references to the state requiring, the state being required to purchase a bond.
Let me scroll through it, Peggy, before you continue. So the first place where it's removed is this paragraph 1.
Right, and that is that's where a conservator is appointed, and this would say this is in the general conservator part, and it says this requirement of a bond does not apply to a public conservator.
And the second section is essentially the same?
Correct.
And then this section KK3.
Right. So part 7 of Article 5, so all those that are those sections that start with 5-7 something, that's the public guardian and public conservatorship statute. And so right now you can see that section 5.7.10 requires a bond. This language just reverses that and says the bond is not required.
And again, it's not required because under the current Maine Tort Claims Act, public guardians and conservators are immune from liability.
Correct. So the question of any kind of remedy is not really part of whether a bond is required or not.
Okay.
And then yeah,
go ahead.
KK4 is just talking about the different amounts that are paid, and it strikes out bond premiums because the state wouldn't be purchasing a bond anymore.
Thanks. Before I'm going to stop screen sharing so that we can see if committee members have questions. And I also wanted to provide a little bit more information. As Peggy mentioned, what we're voting on today doesn't address the underlying issue of whether or not a public conservator or guardian should be liable. That's been addressed by the Maine Tort Claims Act. We heard from Legal Services for the Elderly that they think we should take a look at that and reconsider whether the Maine Tort Claims Act should maybe create an exception to immunity for those claims, but that's not something that we can do in the context of voting on the budget today. I actually spoke with Attorney Delicata from Legal Services for the Elderly about proposing separate legislation where we could fully vet that idea of whether or not there should be immunity in these cases. But for now, there is immunity. And what we're voting on is whether we should make the law consistent with that immunity and consistent with the state deciding not to spend $14,000 a year on a bond that's never going to come into a play because the state is immune. Peggy, did I summarize that? Okay.
Excellent job.
Okay, it's a confusing issue, and I know everybody wants to understand where we're headed on this. So I'll turn to committee members and see if anybody has questions. Tom?
I actually have a motion
You may proceed.
that we approve the statutory changes contained in Part KK and also the initiative to remove the funding for the bond as proposed in the budget.
Is there a second on the motion? Representative Babbage seconds. And is there any discussion before we move on to a vote? Go ahead, Representative Libby.
Thank you, Madam Chair. And I want to say that I appreciate the time to look into this and read up on LD 82 from the 129th. As a fiscal conservative, I certainly feel the tug to support this, but at the same time, understanding what current law is, I do feel that for me to vote for this would be condoning a lack of accountability. And that is why I'll be voting the way I am. Thank you.
Thank you. Is there any more discussion pertaining to this matter before we move on for a vote? Not seeing any hands. And our committee clerk is here and ready to call the roll. Ms. Panett, you can go ahead.
Thank you, Madam Chair. Senator Carney.
Yay.
Senator Carney votes yes. Senator Sanborn. Senator Kine. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
We're voting on.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Senator Keim. Thought I saw her.
She's coming in.
Is she coming?
Yeah, let's just give her a moment.
There she
Sorry,
is.
I don't. Hi, everyone. I don't know what we're voting on, so I guess I won't vote at this moment.
That's fine. I believe if somebody's present at the meeting,
Right.
can they vote afterwards? I don't know the answer to that question, but would you like a refresher on what we're voting on?
Oh, okay. I'll vote yes.
Senator Keim. Oh, I'm sorry.
Go ahead.
Senator Keim votes yes. Representative Hagan. Representative Hagan is absent. I'm going to count again. 1, 2, 3. 11 members voting in the affirmative, 1 member voting in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. So that finishes our work on part double K. And now we'll move on to the remaining part of our work on the supplemental budget. And that is our work session on the Maine Commission for Indigent Legal Services portion of the budget. I do have that the budget document available to share. I will let committee members know that there were no initiatives in the proposal that we received from the administration. So don't know that it makes sense to share it, but I'm happy to do that. Would anybody like to be refreshed with what the original proposal in the budget was? Looks like everybody's all set with that. Representative Evangelos, go ahead.
Thank you, Madam Chair. You sent a nice document out to us that really looks like it simplified the Encyclopedia Britannica here.
Yeah, I was just going to get to that, and you can ask a question, or I can go ahead and.
No, I want you to go ahead. I just want to make sure that this is the comprehensive proposal outside of what the governor's proposal was. Is that correct?
I don't think it's a simple yes or no question. But let me.
I'll wait on it. Thanks.
Yeah, no, I appreciate you introducing it. And so let me just let all committee members know that I did either send you individually or I sent to your caucus leads a proposal that is really designed as a way to frame our discussion this morning. I felt like all of the information we had needed to be organized in a linear way so that we could make sense of it and focus on each element of the aspects of indigent legal services that we've been discussing. And so I asked our committee analysts to prepare a document that I believe you've all received, and I also have it available for screen sharing. And then Peggy, is it on the available in other formats for people?
I did put it on the Google Drive. I don't think it's posted online yet. I can certainly send it. It's not posted online. I can ask them to put a little rush on that if they can.
Okay, great. Thank you very much. And so basically what this document is that I think and hope you've all received, this document takes the most updated memorandum from the interim executive director for the Commission on Indigent Legal Services, takes his biennial budget memorandum and transforms it into something that looks more like the budget initiatives that we've been voting on in connection with the proposed budget, the proposed biennial budget. And so just kind of from a eagle eye view, initiatives 1, 2, and 3 in the new document that I circulated can be found on pages 4, 5, and 6 of Mr. Andrus's memorandum. And I see a question from Representative Libby.
Apologies, Madam Chair. I am trying to find it. I've lost it seemingly in my email, so I'm trying to find it on the drive. Is someone able to point to where it is there? Or what its title is?
Google Drive, is that where you're looking?
Yes.
So if you're in the biennial budget, there is a subfolder called MCILS Documents and Information, and it is, I'm not seeing it. Hold on just a second.
Okay. Just making sure I'm not crazy.
No wonder. Yeah. Okay.
Yeah, we'll all get there. And while Peggy's doing that, I'm just going to continue the orientation. So basically,
okay, it should be there. MCILS Senator Carney proposal.
Thank you. I see it now.
My apologies.
I just emailed it to her.
I can screen share it as well, just so that people, because I do want us all to be oriented. So have I successfully screen shared it?
Yes.
Great. And am I screen sharing anything else or just the memo?
That's it.
Great. I do have nice pictures of my family on my computer. So just so that people can track it before we dig into the nuts and bolts, Initiative 1 comes from page 4 of Mr. Andrus's memo. And he calls it element number 1 in the memo. But because our budget language is initiatives and the 3 elements he discussed seem to be discrete things that we might want to vote on, I thought it made sense to break them down into initiatives. So initiative 1 is essentially the chart that's on page 4 of his memo. And then initiative 2 is the shaded box on page 5 of his memo. Initiative 3, and let's see if I can make this a little bit bigger. Excuse me for a second. Initiative 3 is the chart that is on page 6 of the memo. And again, it's just the shaded boxes. And then, and this might throw you for a little bit of a loop, but initiative 4 is actually on the page 11 of the memo, paragraph D. And the numbers are the difference between the baseline budget and the proposal, which is paragraph D. Initiative 5 takes us back to page 8 of the memo. It is described on page 8 as initiative 5. However, the memorandum talks about an hourly increase to $100 per hour, and this relates to an hourly increase up to $80 per hour, and from the current 60. And so the dollar amounts are the difference between the $60 an hour, which is in the baseline, and the increase that is initiative 5. Initiative 6 is initiative 2 at the top of page 8. And the dollars come from both the position, the pay and benefit for the position, plus supplies that were outlined in the October budget document that we've looked at before, which actually was created before Mr. Andrus became interim executive director. Initiative 7 is initiative 3 from page 8. And those numbers come from the same place, from that October memorandum. And it's both pay and benefits plus supplies. And then Initiative 8 is what is labeled as Initiative 4 on page 8. So I know it's a little funky to be going back and forth on the numbers, but it seemed like this was an order that made sense given what we've been asked to address as a committee. So with that, I'm going to stop screen sharing and just see if there are, before we dig into each initiative, if there are sort of big picture questions that committee members would like answers to before we proceed. So I have a big picture question. Does everybody have the documents available that they feel like they need to look at? Yeah, it looks like that is good with everybody. Are there any other big picture questions? Yeah, Peggy?
Sorry, I think that there might be, I don't mean to throw a wrench in your discussions, but I know Justin Andrus is putting together the other costs that weren't necessarily included in all of these, the all other lines, which weren't necessarily included in all of these numbers. If you remember, the submission in October actually didn't include everything. And so if you get to the point where you want to look at the absolute total, he's going to have those numbers. And he's actually put together a sheet like yours, but has included in the all other, if you, when you get to the point that you want to look at that.
Is his sheet, does it follow the same order and initiatives as ours?
It does.
Great. Is it ready for prime time, or do we want to take a little break while he finishes it up?
I think it's ready to go. I can email it and post it in the Google Drive, and and I can try to get, we can get it posted online too. However you want to proceed. I want to make sure that you're dealing with the whole picture, because you definitely have the personal services costs in all these, which is in some cases all there is, but there are some, like all other costs for setting up these offices.
Okay, I think at this point, because this is a very important issue and a public work session, that it would be really helpful to pause for a minute. I believe that Mr. Andrus did email that to you,
yes.
Peggy, and if you could please put it on the committee materials page so that it's publicly accessible. And then also if you could email it to committee members and put it in the Google Drive. I know that's going to take a couple of minutes, and I just ask everybody for a few minutes of patience. I think that it'll be really, it's terrific that he was able to do that on such short notice, and it'll be really helpful for us to have the actual numbers when we're going through this and casting our votes.
And just so you know, it has the same name except it's dated 3/16. So it's going to look just like it, except it's got the all other line.
Okay, so we'll just sit tight for a few minutes, and
it's in the Google Drive, it's emailed, and now we'll try to get it online.
Thank you. And I'm just going to pause for a moment because I would like to print it out, and I need to run over to my printer. It's easier visually for me to follow it. So, and other committee members, if you need to do that, please go ahead. Thanks for your patience, everyone. And I'm just going to wait another moment because I think that other committee members may have stepped away to grab the document. Committee members, when you are ready to proceed, just please let me know.
Just to clarify, the new one has a watermark across it that says revised 3/16/21, 10:51 a.m. So if you've got that as a watermark, you've got the right one.
Great. And Senator Sanborn and Senator Keim have also just joined us, and we'll do a little committee introduction. And Senator Sanborn, I just wanted to let you know that we are working with a new document, and you're on top of that. Okay, I figured. Thank you. Do you want to go ahead and introduce yourself?
Sure, I'd be happy to. Thank you, Senator Carney. I'm Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook. And glad to be here this morning. I'm playing double duty, so that's why I'm just appearing, as I'm supposed to be over in another committee chairing as well. So here I am.
Thank you. And Senator Keim, would you like to introduce yourself?
Thank you. Yes. Hello, everyone. My name is Lisa Keim, and I represent Senate District 18, which is Northern Oxford County, and 2 communities in Androscoggin.
Thank you. And Representative Evangelos, you have your hand raised. Is that a new raised hand? Go ahead.
Yes, I have the documents labeled from Peggy in reference to the work you did, but is there another document coming from Justin that she was going to forward to us? I haven't seen it yet.
So it's the one that we just received via email from Peggy, and it looks similar. The type is a little bit smaller than previously, and it has written across it in watermark revised 3/16/21 at 10:51 a.m. It should be in your inbox.
Okay, I'll check. I'll get back to you if I can't
And
find it.
if you don't have a printed version of it, I'm going to screen share because I think that's a really efficient way to move through our work as well. So I think the next thing that I would like to do is to hear from Mr. Andrus just briefly so that he can explain the updates that he did to the committee. And so I am going to bring him through cyberspace to our meeting.
Good morning.
Welcome, Mr. Andrus, to the Judiciary Committee and the work session on the Indigent Legal Services budget. Thank you for working so swiftly this morning to update the numbers. Can you just describe to the committee, please, the additional work that you did on this new initiatives document?
Yes. So good morning. Thank you. The document we've been discussing, the watermark document, I did a few things. First, I incremented at the rate of 3.2% the salary and fringe costs, personnel costs from 21 to 22. I then added in all other costs based on what we had calculated in our previous work, and then added a line for total costs, which is both why the print got smaller and why it rolled off onto another page. Otherwise, the information is the same. The starting point for each were the numbers that were provided in the document. They appear to be the same numbers that came out of mine, which makes sense, of course. And that's all I've done.
Can you give us a little bit of an explanation as to what all other means, please?
Sure. If you, I can get a page reference while I'm doing this, but the all other costs are the costs associated with folks like computers and glasses reimbursements, and for lawyers bar memberships, and there's a breakout of them in the, I don't know what documents have been distributed to you. I provided a spreadsheet.
I don't know that we need the specific breakout, and we can ask you questions about that. I just wanted people just to have a general understanding of what the all other is.
Sure. It's all of those ancillary costs that are neither salary nor fringe benefits. And they range from some things that are very, very specific to some things that are general. The numbers change from year to year because there are some startup costs. We don't need to buy a desk every year. We don't need to pay for desks to be installed every year, for example.
Terrific. Thank you. That's a great explanation. Since the all other category is kind of new on this document, before we dive into the initiatives, do committee members have specific questions about the all other category? Okay, I think your explanation was right on, Mr. Andrus. Okay, at this point, I think I would like us to start working through the document, taking up initiative 1. And last week when we met and we started our work session on the budget, we talked about the structure of kind of building out the basic central office staffing for indigent legal services. And Mr. Andrus had explained to us that the most impactful change for the least expenditure of general funds would be to build out the basic central office staff by adding 2 attorneys, kind of a lead attorney and a second attorney, in a subdivision that related to supervision, training, and attorney qualifications, and to also add a paralegal in that role. And then to have another subdivision that pertained to the auditing, both of billing for attorneys who are providing defense and then any other outside invoices. And similarly, that subdivision would have a lead attorney, a second attorney, and a paralegal. And the total cost of all 6 positions and the other costs, the computers, bar membership, and that sort of thing, are now all reflected in initiative 1. And so at this point, I'm going to open it up to questions related to initiative 1 on the part of committee members. And I'll leave it at that. Do committee members have any questions about initiative 1? I'm not seeing any questions. Let's see. Senator Keim, you have great. There are a couple of questions. Senator Keim and then Representative Evangelos.
Hi, Mr. Andrus. Thanks for being here today. I'm so relieved that you are part of this conversation. I was thinking over the weekend how it would be so difficult to get through this without you being here to answer questions. One of the things that I was wondering about, and I mentioned before, but I am concerned that there's so many attorneys being used to staff the office as opposed to using some other just qualified people to do the work, with attorneys overseeing. With the budgets and with positions in Maine, we we definitely see often reorganizations of positions where if someone is doing more work, they're asked to have their position reorganized or something, and the salaries go up. But I think that when we create any new system within the state, we have to be really careful that we're not over hiring, right? We're not putting people into a position that are more qualified than they need to be, because that is at great cost to the state. So I'm going to sort of continue to ask that question, but about every area. But I think that it's important that we look at making sure that these are necessary and fit. And I'd like to hear your response to that.
Good morning, Senator. Thank you. I am also very relieved that I'm able to be here today. I think it's really important that when we look at what makes a person qualified to discharge the duties of these offices, we think about the need, not just for technical qualification, say to do an audit function, to be able to do that evaluation of the document set and the mathematical review, but also the ability to perform discretionary review of the propriety of charges or the necessity of work that was done, or the quality of work that was done. And in order to do that, I believe that the core functions have to be performed by attorneys, not necessarily say the document gathering. The paralegal on the audit side could participate in document gathering, but the review of the information gathered to determine whether the charges are reasonable and necessary really is something that requires experience in the field to be able to perform. I think last time I talked very briefly about the idea that when, if I had a civil case, I would need a physician to tell me whether the medical services were necessary and proper that my client received. And the same thing is true here.
A follow-up, if I may.
Yes, yes.
Thank you. I understand that. I agree with what you're saying. I just also wonder if it's not possible to train people to look for certain things, because it is a great deal of this is voucher review, and a great deal of it will become repetitive, I believe. And, if there's a paralegal or someone, of course, people would need to be familiar with what was happening. And so that, I guess I'm pushing back a little bit on every single one of them, that does the review needing to be a lawyer.
I don't think necessarily everyone who does the review of the math needs to be a lawyer, but the training that's necessary to teach somebody what the standards are is law school. And the experience that's necessary for somebody to develop the framework to make an informed decision about whether a practice is consistent with best practices for counsel really is practice. And so I don't see the route to training somebody to make those parts of the decisions who haven't had that experience. Math, maybe lawyers shouldn't do math at all. Certainly not all lawyers should do math, and not all people who can do math properly for this function need to be lawyers. I don't disagree with that at all. But there are two sides to it, and the math problem is only part of the analysis of whether or not billing is proper. And similarly, on the training and supervision side, a non-lawyer could certainly look to see whether there's been compliance with the requirements of following documentation, for example. Does the documentation exist? Does it not exist? That doesn't necessarily need to be a lawyer. Does the documentation reflect an appropriately informed and professionally reasonable judgment about how to serve the client? I do think it needs to be a lawyer. When we get to the training function, we run into the same kind of thing. When somebody's developing a curriculum to present to lawyers, I think that probably needs to be a lawyer for that person to be able to, again, identify the correct standards and the ideas and options about doing it. Now, it may be possible. I would love to see a day when we have some packaged curricula that we are using regularly and presenting. That doesn't necessarily have to be a lawyer. Or if something involved some pre-presented or recorded things, not my preference. I would like to get back to live stuff. The person proctoring that doesn't necessarily need to be a lawyer. But the development of things that involve professional standards, I don't know how to train a person to do that other than through the training and experience the lawyer receives.
Did you have an additional follow-up, Senator Keim?
I do. If you could tell me
Do you mind, Senator Keim, if I just interrupt for 1 minute? 'Cause I wanted to point out a couple of different things. You know, as an attorney in private practice, I did a lot of reviewing of my own bills, and part of that is really an exercise in understanding the relationship of the described legal activity to the overall scope of representation and the appropriateness of the representation. So I do think that makes sense. The other thing I wanted to point out is that when we get to Initiative 3, the position that's added onto the audit branch is actually a paralegal rather than an attorney. And now I'll turn it back over to you, Senator Keim, for your follow-up.
Thank you. And Mr. Andrus, who would be in this central office building? It would be the director that is in charge of this whole, these 6 positions. They would all be working under the director. Is that correct?
The answer is yes. I envision that there would be some direction, at least moment-to-moment direction, to these groups from the deputy director as well, because there are some decisions that rely within existing policy or protocol, and those don't necessarily require the executive director to make a sort of procedure level decision. And so there's probably room for both people to be involved in that. Yeah.
Okay, I have probably other follow-up questions, but I will leave that for now and let someone else ask questions.
Thank you. Representative Evangelos?
Thank you, Madam Chair. I'll defer to anyone that has a question because I was prepared to make a motion to accept the initiative, but I don't want to cut off discussions.
Are there other questions on the part of committee members? Senator Keim, were there questions that you'd like to ask before we move on to a vote?
Yes, I have one other. I guess my other is the assumption that one attorney needs to be overseeing the other attorney, which if this whole group works under the deputy director and the director, why do you feel it's necessary that one attorney have supervision over the second in both divisions?
So I hear in that 2 questions, and I'm going to try and answer them as directly as I can. The first is, why 2 attorneys in the division at all? Why not 1 attorney and 2 staff? And my answer for that is because there will be enough decisions that are discretionary and need that frame of reference that I think that if you only have 1 attorney and 2 staff, you're likely to get in a position where the staff has the potential to be underutilized and the attorney overutilized. And let me just please also say that it is not my perspective that attorneys are better at all the things. These are discrete tasks that require the attorney perspective. And there are many places in the world where I wouldn't recommend an attorney's tool set as the right option. In terms of why one should be a sort of superior to the other, it's to avoid the need to have the executive director micromanaging that division. So that if there was a workflow decision to be made, or who does what case or what evaluation, or whether there were decisions to be made inside the division about, how to divide time between random checks and specific checks or something like that, there just needs to be somebody in the position of directing that flow. I don't see them as directing the policy of the office, but I do see them as implementing that flow in a way that will keep things efficient by having a decision maker for that subunit.
Thank you.
Are there other questions on the part of committee members?
Before we vote on this initiative, I would appreciate a corner caucus.
That's fine. I would as well. So at this point, let's have a motion and a second, and then we can go to our corner caucuses. Representative Evangelos?
I'll move that we move the item in, including the ancillary costs explained by Justin. Get on my right computer here.
So you're moving all of initiative 1 on the 10:51 a.m. memo?
Yes, 717,189 and 719,138. 2-year proposal. Move it in, ought to pass.
Is there a second?
Second.
Seconded by Senator Sanborn. And at this point, we'll have corner caucuses. Senator Keim, how much time would you like?
I would say no more than 10 minutes, maybe just 5.
Okay, that sounds good. We can, and then at some point, we're going to take a lunch break, and I'll just put it out. Do we want to take a more extended break right? Well, I think we should finish up our vote on this. So let's take a 10-minute caucus. We will return at 12:25. And Representative Evangelist, did you have a question before we break?
Oh, I just, I should have prefaced my motion with the call has been for accountability, and this is an important piece of it, and that's why I'm supporting it. That's all I wanted to add. Thank you for that, Madam Chair.
Thank you. And Representative Libby?
Thank you. I just wanted to point out to the folks in my caucus to look to text or to Facebook Messenger for a link. Thank you.
Right. Okay, let's take a break until 12:25.
take it back, Judge.
All righty, buddy, thanks. There, it looks, I think my mic's on. Hey, Tom?
Yes, Jeffrey, we're
My mic
live
was
here.
on. My mic was on, wasn't it?
Yes, sir.
Did I talk about anything besides planting stuff?
Nothing to be concerned about, Jeffrey.
Thank you, Tom.
Okay.
Planting, Tom.
I was worried about being lost in cyberspace for 10 minutes, but I see I have not missed a great deal.
We used to watch that show when we were squirts, Chris, remember?
Which one are you talking about?
Lost in Space.
Oh. I was a Tom Terrific kid.
It's good to hear, Representative Babbage.
Yeah, you take anything you get.
I arranged my kindergarten so I could watch Captain Kangaroo and Tom Terrific.
I was already growing a garden when I was in high school, so the kids nicknamed me Mr. Green Jeans.
Oh.
What in the 45 or 6-page document, what page goes along with the other costs that we find on page for this initiative? Can someone help me find that? Peggy, do you know?
So the 45-page document you're talking about is what we're calling the worksheet that has all the spots for voting. Is that what you mean?
No, the
No.
45-page document is what is called the prior submissions PDF.
Oh.
And I was just wondering, I can look through it and try to find it, but this initiative is found on what page of that document?
You know what, that is something, Justin put that together. The prior submissions, I think, is a combination of everything that had been submitted before. And I believe Mr. Andrus is probably best to point out exactly where that is, if I can put him on the spot.
Sure. Two parts to that answer. The first question I heard was about where to find the breakout of the all other costs. And it's not in the compendium of prior documents. It's in the spreadsheet titled October Initiatives, updated March 1st, 2021. And the reason that it's not in the other document is because I couldn't figure out how to make it print in a way that was both legible and wouldn't take 600 pages. In the spreadsheet, there are 3 tabs, one of which is named Central Office, one is Quebec PD, one is Appellate. And if you look in there, you can see the first part of the breakout. All other costs. I'm sorry, I'm trying to organize my thoughts to answer.
Oh, okay.
The initiative 1, as presented on the document with the watermark that we've been talking about, has evolved since I started writing things. Okay, so it starts as at the beginning, it starts on page 1, which was the original change package CA1, which was in the October submission that MCILS made. Then when I realized that there was an error in that document and prepared to testify on March 1st, I prepared the document that starts on page 5. That document has some spreadsheets appended to the back of it. I'm getting to the direct page, but there's a commission staff breakout starting on page 13 of the compendium. I'm using the compendium's page numbers so they're consistent. On page 13 of the compendium, On page 14 of the compendium is the actual breakout of those same information started on the spreadsheet I just discussed, broken out for what the commission should have asked for in October. And so I think that's the best answer that I can give you.
Thank you.
If it would be helpful, I'm happy to screen share anything that can assist with this discussion. Representative Libby, go ahead.
Thank you. This is probably a question for Mr. Andrus. At one point in this conversation, we had a little bit addressed the fact that most folks are working remotely these days. And I thought that there was a possibility that some of these positions would be remote. So I'm wondering, are we really looking at a figure of almost $25,000 for office furniture and those other startup costs? And how much of that is reflected in these other costs?
I'm not sure I'm qualified to project when we would return to an office setting versus when, how long we're going to continue to work remotely. It would be my preference as a manager to have people co-located with me for the most part, whether I wind up ultimately in the role, whether somebody else does, how they feel about it, what the rules are, very difficult for me to project. So I don't mean to dodge that question in that way. But it's certainly possible that some of these people would be working remotely at least some of the time. I do think at the outset, to the maximum extent that is consistent with whatever the health rules are at that point, they should be here. Because I think the fluidity of the dialogue is greatly improved by the ability to stick your head around the doorway and say, hey, I'm stuck again, without the disincentive to pick up the phone 900 times in a row. I know that doesn't precisely answer the question you asked, but I think that's the best I can do given the uncertainties of what we're going to look at.
Sure, I can certainly appreciate the uncertainties at this time.
Committee members, are there any other questions? Go ahead, Senator Kime.
Thank you. Mr. Andrus, I was wondering, is it just usual and customary that over and above healthcare, we would also be paying for eyeglasses? Do you know?
My understanding is that the state provides a reimbursement benefit for all employees who are working at what they call a VDT, a visual display terminal, more than a certain amount of the time. Practically speaking, I anticipate that all of these folks, like many of us, are going to spend too many hours in front of a computer. So that's where that came from. It's an HR benefit. It's not a prime that we're proposing to offer to our employees specifically. And they are, there are two prices in that reimbursement. I think there's $100 and $150. And I think the trigger there depends on the type of prescription a person has. And there may be people who don't wear glasses, of course. So I don't know, I can't project. I've done my best with this to err reasonably highly, not putting things in that don't belong there. But for example, we were asked at one point, do the HR numbers imply family benefits? And they do. That turns out that that's how everybody gets us numbers. And so some of those could prove to be high, but they're safe. And the glasses thing, my recollection is that we factored in half participation for the eyeglass benefit.
Representative Evangelos?
Thank you, Madam Chair. I just paid my Blue Vision bill. As legislators, we are entitled to the benefit, but we have to pay it out of our own pocket. It's $13 a month for Blue Vision, so we're not talking a lot of money here.
Representative Sheehan?
Thanks, Madam Chair. Representative Libby's rationale for her no vote earlier this morning was really compelling to me, and I'm just finding it echoing in my ear as I think about this initiative. we have to balance fiscal responsibility with the accountability that this moment urgently demands. And I am just not comfortable imagining anyone without full credentials and experience overseeing audits of attorney performance. Accountability has been an issue, and I think we need qualified folks to lay that foundation of accountability. So that's why I will be voting in support of this initiative.
Thank you, Representative Sheehan. Representative Harnett?
Thank you, Madam Chair, and building on Representative Sheehan's comments, I want to remind people we're not operating in a vacuum here. We've had in our hands for probably the last 2 years now, a report by the Sixth Amendment Center that highlighted a litany of concerns with the way indigent legal services are being delivered in the state of Maine, questioning whether or not we are living up to our constitutional obligations. We also had an OPEGA report dealing with issues of billing and other concerns that OPEGA raised with oversight issues with the commission, and the commission's been trying to address those. I don't know how we could possibly oversee the performance of over 300 attorneys, private attorneys that now work on a contract basis, train those attorneys without having attorneys doing that. You cannot bring in non-attorneys to train people on how to be a lawyer or how to represent a criminal defendant. I've seen a lot of effort by members of the commission to try to identify the positions they need to make this organization work. And I am comfortable with what is being proposed, and you may hear that over and over again today. I have trust in the work that they have done, and I think we're talking about bare bones minimum here. So I will be voting in support of the motion.
Thank you, Representative Harnett. I would just also indicate that I'm going to be supporting this motion. We did ask Mr. Andrus to give us a proposal, and he's looking forward in formulating this proposal and identifying the positions that would maximize the effectiveness and performance of the organization with the minimal amount of expenditure. And I really appreciate how focused he has been on this. I feel like he's given us really good, solid information, and that his consideration is thoughtful and well-founded. And so I'll be supporting it as well. Is there any additional conversation before we move toward a vote? Not seeing anybody who wishes to be recognized for discussion. And so I'll turn to our committee clerk, Ms. Panett, for a roll call.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Sorry, thank you. Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Hagan. Representative Hagan is absent. That's 13 members voting in the affirmative, 0 in the negative, 1 member was absent.
Thank you very much, Ms. Panett. Committee members, I would like to move on to initiative number 2. I realize that we do need to take a break, but it feels like this is related to our previous initiative. And so I think it makes sense to discuss it at this time. This is the initiative that Mr. Andrus proposed in order to basically provide office staffing that would enable he and the deputy executive director to focus on the more core functions of their jobs, while having a staff person assist with communications and other types of work. Do committee members have questions for Mr. Andrus about initiative number 2? I'm not seeing any questions. Oh, there we go. Representative Harnett, I think the way it works is that the rightmost square is first. So Representative Harnett?
If there are questions, I was going to make a motion, but I see if there are questions, I'll hold off on that.
Okay. Representative Libby?
Thank you, Madam Chair. I just would like to know where we can find initiative 2 in the October initiatives updated March 1st. Specifically the other costs. Thank you.
Are you able to answer that, Mr. Andrus?
All right, I forgot to click. I only heard part of that, Representative Libby. You wanted to hear where that was in the March 1st document?
Yes, where the breakdown was for this position in the March 1st document labeled October initiatives.
In the October, so this position, let me just start that over. Structuring these elements the way they are was something that occurred after March 1st, as I had conversations with members of this committee and was doing my best to answer their questions. And so it isn't in the March 1st document. Excuse me, because I need to find where we did that, which document. So give me 1 second. I may not have printed that, Representative. I apologize to you if I have excluded that from the documents.
Okay.
Because it didn't fall into one of the prior sets. I can try and address a little bit what it would look like, however, because it was functionally equivalent to the other non-attorney folks. And so if you, let me just get a page number for you. Give me 1 second, and I'm going to see if I can do a little better. If we look at the spreadsheet that was entitled October Initiatives updated March 1, 2021, it's got, it's all in the aggregate. So I can't break for you right this second, but I can try and do it for you over lunch. And I know that's not the goal of the timing of the motion, so excuse me, but I don't want to keep you waiting. How to break it out. But what we did is we took out, this person wouldn't have bar dues, but they would have potentially a cell phone. The eyeglasses reimbursement, as I said, was at 50%. They wouldn't need a legal research subscription. As I worked down the list from the October Initiative spreadsheet, they would have furniture, they would have a telecom charge, they would have a computer, there would be a charge for payroll processing. And so what we did is we used the numbers consistently for folks. The only difference between the attorney and non-attorney categories is the lawyer specific things like bar dues.
I would be interested to see that, because when you do the math, and I realize this is very rough math and I'm doing it without that information at hand, that 7,600 number is roughly 1/6 of the 47,000 above in Initiative 1. And so I'm just wondering where those differences are in the costs, if the bar fees and the mileage that I'm assuming is something that the attorneys would rack up with the mileage versus central office staffing position. So just would love to see that breakout.
I will try and do that for you.
Yeah, I think the difference is, maybe I'm misspeaking, but the other costs in the previous line are for 6 positions. And this
Right.
is just for one position?
Yeah, so when you divide the 47,000 roughly by 6, that's 7,800 or so, which is pretty close to the 7,600. So I'm just trying to account in my brain here for the difference in not accounting for mileage or bar dues, legal research subscription, the things that Mr. Andrus mentioned would not be needed for a central office staffing position.
Okay.
So, Deputy Director Maciag is in the process of sending me the worksheet that we used for that purpose. Excuse me for interrupting, sorry. But I want to try and get you that information as quickly as I can. So,
Okay, we'll put that question on hold because I see that Representative Moriarty and Senator Kime both have questions. Go ahead, Representative Moriarty.
Madam Chair, thanks. Tell me if I'm correct. In the March 10 report from Mr. Andrus on page 5, aren't we talking about the central office position described as element 2?
Yes.
So that's the source.
But I think the specific question has to do with the other costs, kind of the office setup costs, which are not included in the memo. I think that's what we're trying to get to the bottom of. Senator Kime, did you have a question?
Yes. I think it goes to the other costs as well. I'm curious about if this is an office specialist, if mileage is included and a cell phone is included. Is it typical that we would be paying people to travel back and forth to their office location, and that we provide cell phones to all office staff? Do you know, Mr. Andrus?
it is not typical that we would be adding mileage for the commute. That's not what that would represent. When we see mileage, it would be mileage that would be work related other than the commute.
Okay.
And as far as the cell phones, it is my understanding that we would provide cell phones typically to folks who may work in part from outside of the office, in part because whatever they do with the cell phones, is subject to FOA. And so we don't want necessarily people using their private phones. I will say that the phones we tend to get are flip phones. They're not data enabled. They may text or something, but they're not data enabled. I was reaching for mine, it's out of reach. It's delightful. I wish I could have all of my phones just be phones, but we're not getting people iPhone 12s and unlimited data plans. I think the phone itself is essentially included. There's some nominal cost, like a penny, so that there's a sale, but it's very, very minor. And I'm working, and I don't mean the multitasking, I'm working with Kelly this data for Representative Libby. So sorry for being distracted there, but we're trying to keep those costs to a minimum. We're certainly not paying people to commute.
Thank you.
And Mr. Andrus, do you, the breakdown of the other costs, is that something that is available now, or should we take a little?
Deputy Director Maciag is producing that right this second. She's been pulling the pieces, and you can see my eyes go to the Teams chat. But I'd rather than try and assemble that on the fly, she's doing that into one list, and I'll get it to you momentarily.
Okay.
Yeah. I would, if I may, like to recognize her work. I was thanked for producing all of this data for this committee, and I did work hard at that. But Deputy Director Maciag, to May in HR, Beth Ashcroft in budget. We had a lot of support from a lot of corners getting the information to you, and I just would like to recognize those people.
Yeah. Thank you for recognizing them, and please extend the committee's thanks to them, because we do really appreciate how thorough you've been in response to our requests. And we'll just sit tight for a moment while the information is gathered. Thank you.
You'll see me step up, walk around the corner. Senator Carney and Peggy, if I'm going to send a little spreadsheet with the numbers and how we arrived at them, who should I send it?
It looks like Peggy is on the phone. And so are you thinking that I would be able to screen share them?
Yeah.
Why don't you send them to my legislative address and I will grab them and screen share them. Thank you. That's a great suggestion.
This is not the quickest email I have ever sent, but it does have the data.
Thank you. I'm looking for it right now. Okay, so I'm going to try to screen share this. I've never screen shared an email before, so hopefully it will work. All right, am I showing just the email and nothing else?
You are.
So by way of explanation, this is on the left column. This is pulled from one of the previous spreadsheets, but it was for two non-attorney folks. So the right column, I just cut it in half, working as quickly as I could so you don't stay waiting to get us down to. And I recognize the numbers different than what I had for enhanced central office staffing. I'm looking for what I missed here. But it doesn't have, it may be the travel, because the travel is out of here. Senator Ellie has made a cleaner version of a spreadsheet, and I'm sending that to you as well, so you can see it. It also has FY22 and 23. So keep evolving as fast as we can to get you information.
All righty, let me, I'm going to end this screen share, and unless our committee members still looking at this, okay, I'm going to end the screen share and then look for the other email. Give me just a moment. Okay, I'm having a little bit of a challenge downloading that, so give me just a minute, everybody, please.
I just pasted the table that's in there into email body for you too, so it should arrive in that form momentarily as well.
That's much easier. I'm going to screen share that now. Is that helpful, committee members?
Again, this is from that same table I referenced a moment ago. And so it was for 2 employees in the component of the spreadsheet that it came out of. So below the line, I cut that in half to show 1. And you can see the reduction in first year to second year costs because we're not buying, more furniture. We're not buying more computer stuff.
Committee members, if you have specific questions about this spreadsheet, please use your electronic raise hand because with the screen share, I can only see a few of you. Are there questions about this information? Our committee members finished reading the document? All right. Do committee members have additional questions about Initiative 2? And I'm a little lost. I'm not sure that we have a motion yet on Initiative 2, but I believe a motion is in order. Representative Harnett?
I move that we approve Initiative 2.
Representative Evangelos?
I'll second it.
Is there any discussion? Representative Harnett?
Just had to take my hand down.
Committee members, is there any discussion before we move to a vote? Not seeing any, and I am seeing our wonderful clerk, Ms. Panett.
Madam Chair?
Yes.
In the updated memo that we had from Mr. Andrus, the numbers, is a dollar amount moved or just the passage of the initiative?
I think they're one and the same.
I see. Okay. I was wondering why they both were 95 with different numbers above for 22 and 23. But that offset is equal, is it, in other costs versus salary?
It's the reduction in the costs of furniture and things that don't get duplicated year to year, then offset by that 3.2% increase in the salary year over year.
But the reduction in, oh, I see. No, it isn't exact. Okay, but it's 95,000 on both. That confused me for a moment, but I got it. Thank you.
Thank you, Representative Babbage.
Sorry
Okay, I
about
think
that. Thank you.
we're ready for the vote, and you may proceed, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckitt.
Yes.
Representative Galgay-Reckitt votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Hagan. Representative Hagan is absent. 11 members voting in the affirmative, 2 members voting in the negative, and 1 member is absent. That's the vote of the committee.
Thank you very much. It's now 1 o'clock, and I feel like it would be good for committee members to have a little break before we move on with the rest of this, because I think with the thorough review we're doing, it's going to take us a little bit more time this afternoon. So Senator Keim, is it acceptable to you if we take a break until, would you like a 45-minute break until 2 o'clock, or a half-hour break till 1:45?
I'm fine with either.
Committee members, how do you feel?
I
Tom?
think 1:45.
1:45?
1:45 is fine.
Representative Newell, is 1:45 okay with you?
Yes, thank you, Madam Chair, but I had a question.
Yes, go ahead.
Just on the remaining initiatives, I'm just wondering on the other costs, are those breakdowns going to be provided ahead of time?
That is an excellent question. And I will turn to Mr. Andrus. Do you think that you could help us with the breakdowns on the other costs?
Initiative 3, Madam Chair. And Initiative 6. And Initiative 7.
Thank you. Are
Thank
you
you.
able to do that for us?
I am.
Do you need more than half an hour?
Don't think so. I believe they're all broken out. The only exception might be if I may have exemplars of attorney versus staff as opposed to in
Okay.
every initiative like that, but they break the same way.
Okay, great. So then looks like a half an hour will be adequate. So committee members will reconvene at 1:45. Thank you very much. Hello, everybody. Looks like we are returning from our lunch break, which I have to say felt quite good. And Mr. Andrus, I received from you, I think, 4 cost breakdown emails.
You should have 4 emails from me, one of which is the list of the costs associated with each employee. I thought that might be useful instead of just seeing aggregate numbers, and then folks can see that. And then there's one each for each of the initiatives. The last one's ugly because I didn't have it in the form I wanted to. So the first 2 are a lot cleaner than the last one, but the numbers are there. And if I may, the conflict I thought would keep me from the day has reasserted itself for me at 3. It should be very brief, but I will need to address that. Both Commissioners Tardy and Carey will be available to continue, as will Ellie. So there should not be any lapse in the ability of the agency to present information to you.
Thank you. And when we get to the cost breakdowns, I'll just ask that you refer me to the ones that are pertinent by the subject line of the email. That's how I saved them. Okay, great. So are we all ready to resume our work? Looks like we are. And so I think our next, the next initiative to consider is Initiative 3. And I will turn to Mr. Andrus. Just can you briefly give us a summary of Initiative 3? And then I found your schematic on page 6, I think it was, of the memorandum also helpful. And if there's anything you want me to pull up on screen share while you're talking to us, I'm happy to do so.
Okay, so thank you. Initiative 3 just continues to build out the office so that we can get closer to being able to provide the degree of attorney oversight that is acceptable in the industry and consistent with ensuring that indigent clients are receiving adequate representation, constitutionally adequate representation. So in Initiative 3, there are additional attorneys and paralegals. We are starting to break out the attorney supervision subdivision into sort of 3 groups, one providing direct quality of representation, supervision, and guidance, one providing training, and one engaging in investigation. And in each of these, at the training and investigative subdivision, there's 1 attorney and 1 paralegal, because I agree with the proposition that not everybody involved in each of those functions has to be an attorney. At the supervision, these would be in part attorneys going into the field to provide field supervision over our contract attorneys as they perform in the field. And for that reason, those people should be attorneys. We can't have a non-attorney supervise an attorney under the rules of professional conduct. I also don't think it would make good practical sense. So page 6 of the memo has a chart. You can see what the office would look like in terms of its new employees. Above that, and maybe I should have done this, above that would be the existing office staff. Initiative 3 in the breakout contains the accurate numbers. If you put the email on the screen that I called per person or something like that, per person cost, Senator Carney, I think that's what I used.
I was muted. Yes. Give me 1 moment to pull that up.
One of the things I was surprised to learn as we talk about this, we'll see this on the slide, is that our computers are rented from OIT. The agency doesn't own them, so there are ongoing costs associated with them, but we have to buy external keyboards and mice and monitors, and so we own them. And so when you see this document, you'll see that well, not this document, you see that the next step when we're looking at the costs going down, you'll see the keyboard and the mouse and the monitor coming off, but the OIT and telco costs stay high. So this is what we were looking at. This is the backup for the numbers that we were seeing before. I think we did look at something similar to this, but this shows you attorney side and non-attorney side. Doesn't include fringe benefits because they're in the fringe line in the charts in my memo. And you can see the salary and the fringes broken out. But here you can see what that looks like. And then unfortunately, the email for Initiative 3 is ugly. But if you pull up, Senator Carney, if you pull up the further staffing to central office email, you can see the breakout.
1 minute here. Initiative 3. Alrighty.
Okay, so two after this are cleaner. But,
hold on a second, I lost it. There we go.
But we didn't have this already broken out. You can see how we did the math. And then you've got the FY22 and 23 numbers. So there is a $305 delta between what I calculated over lunch and what's in the document that is your working document. And I can't account for it. I dropped something. I apologize for that, but we want to acknowledge that. But this is how it breaks out.
You were fading out. Your voice was fading out. Can you repeat that, please?
I wanted to acknowledge there's a $305 delta in between the numbers I calculated over lunch and the numbers I calculated that wound up in the initiative document. And I can't find it. I will continue to think about where I dropped that. But it's $305 across not one person, but across all of the people. And if I can identify that for you, I will. But here you can see all other costs for this initiative.
Committee members, are there questions about the all other costs? I'm not seeing any, so I'm going to stop the screen sharing at this point. Okay, so we are on Initiative 3. We've received kind of a descriptor of the build out and of the other costs component. Are there committee member questions for Mr. Andrus? Go ahead, Representative Moriarty. We're not able to hear you. Thank you.
Sorry. Is it the plan, Mr. Andrus, that these attorneys and paralegals will be based in Augusta and will travel around the state as needed?
Yes.
Supervision?
Yes. So I hadn't considered that perhaps somebody who's based up north might ultimately be useful to eliminate that travel time. And so that might not be a terrible idea. So the training subdivision and investigative subdivision folks should be here. They may go on the road to do trainings, but there's no reason that they need to have a central office somewhere else. Similarly, the auditing subdivision folks ought to be here. So it's really just the supervision people who are on the road. A lot of that is going to come in the form of evaluating the quality of documentation being received by attorneys and reviewing that for consistency with standards that we propose to implement as part of there's a lot of stuff beyond the budget that I try not to get too in the weeds with this committee unless I'm asked. But those people will have a lot of work to do in the office. It could be that one of them should be up north.
Okay, good, thanks.
Other questions, committee members? Okay, I am not seeing any questions related to Initiative 3 or Representative Evangelos. Go ahead.
Thank you, Madam Chair. I see Representative Moriarty still has his hand up. Would he like to speak further? No. Well, again, this particular initiative deals with key elements of the Sixth Amendment Center report. We wanted to make sure that attorneys with correct experience were being assigned to the cases where those attorneys had specific experience in those type of prosecutions. Goes right along with everything that I was expecting, so I'm chewing my Altoid, sorry. I'll move, as long as it's appropriate, Madam Chair, I'll move on to pass.
Thank you, Representative Evangelos. Is there a second? I see Representative Reckett.
I can detail the money if you need it.
I think if the descriptor of the motion to pass Initiative 3 is acceptable. And Representative Reckett, you've seconded that? Okay, so now it's the time for committee discussion of Initiative 3. Are there any committee members who would like to be recognized on the with regard to Initiative 3? Not seeing anybody who wishes to be recognized, so I think we are ready for the vote.
Okay, go.
We're ready when you are. Super.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
No.
Representative Downs votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Hagan. Representative Hagan is absent. 9 members voting in the affirmative, 4 members voting in the negative, and 1 member is absent. That's the vote of the committee.
Thank you very much. Committee members, let's move on to initiative number 4. And Mr. Andrus, I know that you have to leave in a moment. Excuse me, what time did you say you had to leave?
In an hour, Senator.
Okay, great. Senator Keim, did you want to raise a concern or speak to the committee?
This one is just so straightforward. I was just going to make a motion not to pass.
Ought to pass? Is there a second? Seconded by Representative Evangelo. Oh, by Representative Poirier. And I think that we are ready for the vote. Oh, actually, that's premature. I would like to see if committee members would like to have anything to discuss on this motion. We're open for discussion. Not seeing anybody who would like to be recognized for discussion. So we are indeed ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Hagan. Representative Hagan is absent. 13 members voting in the affirmative, 0 in the negative, and 1 member is absent. That is the vote of the committee.
Thank you very much. And that brings us to initiative number 5, which is increasing hourly rates from $60 an hour to $80 an hour. And would the committee like to hear from Mr. Andrus? I actually would like to hear briefly from you, Mr. Andrus. And then Representative Libby, did you have a specific question? Okay.
Thank you, Senator. I think it's been well documented in the Sixth Amendment Center report that in order to provide parity of funding for the contracted attorneys serving indigent clients, they need an increase in their hourly rate to allow them to pay for the things that come to prosecutors without coming out of their direct budget, and simultaneously allow them a reasonable living. One of the things that we're looking forward to doing is implementing standards as recommended by the Sixth Amendment Center to have case count limits and hour limits, and otherwise help provide for well lawyers who are able to then provide excellent representation to our clients. In order to do that, also necessary to ensure that they're able to cover those expenses within that reasonable number of hours. So for that reason, we think that it's appropriate to increase the hourly rate. I'll stop there and wait for questions.
Senator Keim?
Thank you, Madam Chair. I was on a little bit of a hunt for my cord so I could plug my computer back in. I appreciate this initiative, and I've been, very concerned with the lack of controls and the ability for the vouchers to be just the whole system was mismanaged. But I do support this increase, and I believe that if we're going to ask for greater accountability from those participating in the system, that we would also expect them to get a rate that would cover expenses. And it is possible that once the vouchers are more carefully and time is more carefully kept, which is what I strongly am, hearing that is going to happen, that we may not see the cost of this actually increasing that much with the measures that are put in place. So I appreciate this this initiative, and I think it's fair, and I think it's a good one for us to move forward with.
Did you have a motion, Senator Keim?
Sure. I make a motion not to pass.
Initiative 5. And
Yes.
Representative Libby?
I was simply raising my hand to second it.
So we have an ought to pass move on initiative 5 moved by Senator Keim and seconded by Senator Libby. And is there a committee discussion on this initiative? Representative Evangelos?
Thank you, Madam Chair. Just a quick question. Justin, was the reduction from the original thought of $100 down to 80 just in the spirit of compromise in hopes that we can get the funding that we need?
So I need to answer with a procedurally correct answer, which is that the commission hasn't met to approve a different budget. And so these initiatives are the product of my dialogue with members of the committee. And I'm happy to be working through them and thrilled that we're going to see some great progress for the commission. This is a compromise that I think is going to get a long way toward where we need to be.
Thank you for the question and the answer. Committee members, is there other discussion on this matter? Does not look like there is, so I think we're ready for the vote, and Ms. Panett is, I think, ready for us whenever you'd like to proceed.
Thank you very much. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Hagan. Representative Hagan is absent. 13 members voted in the affirmative, 0 members voted in the negative, and 1 member is absent. That is the vote of the committee.
Thank you very much, Ms. Panett. We'll now move on to Initiative 6, which is the Kennebec Public Defender Office. And I believe that one of our attendees wanted, Mr. Cummins also wanted to speak to this. Is that, is it acceptable to the committee that we bring him in to hear from him initially? All righty, thank you. And I will make that occur. So it'll just take a moment for him to transfer into the panel. Thank you for joining the committee this afternoon, Mr. Cummins. Did you wish, well, why don't you introduce yourself? I understand that you are a member of the commission, and if you could introduce yourself and then provide us with the testimony you wanted to give, or with the information, excuse me, that you wanted to give on Initiative 6.
Surely, and thanks for the privilege of being able to address the committee. I am a member of the commission appointed by the governor in the fall of 19. I have spent time over the last several decades very much involved in defender services and indigent defense services in particular. With respect to, and with due respect to particularly the hard work done by Mr. Andrews and Ellie and the staff to put all this stuff together, I think they should be commended, number one. I've listened intently to the discussion of the previous initiatives, particularly those having to do with the staffing of the office, which I know is important as the structure currently exists. And by that, I mean as the commission is currently obligated to perform its obligations, and if we retain this structure, those initiatives certainly have my support. But in my judgment, respectfully, this initiative to support the pilot project in Kennebec County is the most critical, to all of those that are before you today. I believe that this pilot project, if properly funded, can prove to our legislative and executive and judicial branch leaders that a public defender system can work in the state of Maine. We no longer have to be the outlier. And to that end, and looking at the numbers in particular, and this may address in part an observation Senator Keim made earlier regarding personnel structures. Over the past week, I have spent a good bit of time communicating with the National Legal Aid and Defender Association in Washington, D.C., which is prepared to come and assist us, particularly with respect to establishing the pilot project in Kennebec. I know we have the support of the Sixth Amendment Center to that same end. And more specifically, I've dealt extensively with Megan Maloney, the district attorney in Kennebec County, looking at the pragmatic aspects of this and looking at the budget proposal relating to Kennebec. We and I have not had a chance to discuss with my fellow commissioners, nor has the commission had a chance to consider some options to the budget proposals that have been made. But after intensive discussions and investigations, particularly those with Ms. Maloney in Kennebec, we can save a lot of money, particularly in this first year. Looking at the details of the proposal, and this may be on the purview of what you want to discuss today, but my proposal that I'll hopefully be able to discuss in detail with my fellow commissioners when we meet on Thursday, we would, and this is in consultation with the practical realities that DA Maloney has called to my attention, I would eliminate the 2 social worker and the 3 paralegal spots. The reality in Maine today is, according to Megan Maloney, finding paralegals that can be hired while big law firms are looking for them is a virtually impossible task. The social worker positions, I think, can be dealt with in a more discreet way. So what we might think about if this proposal is adopted, that we could eliminate those 5 positions and replace them with trial assistant secretarial staff positions that would be very cost effective. The reality is that if the budget were passed with this initiative as part of it, we wouldn't really have the office up and running until November 1st. There would be an immediate savings in terms of the rostered attorneys whose positions would be in effect supplemented by the PD's office. We would take, and Mr. Anders provided me with some numbers over the weekend suggesting that that office would take about 80% of the workload up in Kennebec County. We're asking for 9 lawyers. That would make perfect sense, and it compares favorably and on a par with the 11 lawyers in the DA's office. There's also the opportunity that is rarely discussed. I know it's implemented in many places within the state, but there's a great opportunity here when we talk about young lawyers wanting to get into indigent defense
Mr.
service.
Cummins?
Yes, ma'am.
I'm sorry to interrupt.
Okay.
This
I'll
is
stop.
like a budget work session, which is a little different than providing testimony in a public hearing.
Yes,
And
ma'am.
it sounds
Okay.
like you're into the testimony at this point.
I get it. Okay, I'll just wrap up. I think this is the most important initiative. I think the budget is realistic, but I think we can save a whole lot of money, particularly in the first year.
Thank you very much. We appreciate your feedback, and I think we might have a costs spreadsheet to display as well. Before you sign off, Mr. Cummins, let me just see if there's any questions for you. Representative Evangelos, did you have a question for Mr. Cummins?
No.
Okay, thank you. All right, any other committee members with questions? Representative Harnett?
Thank you, Madam Chair. A quick question, Commissioners. Do you see in the future a hybrid method or a pure public defender method?
I believe it would be hybrid in this sense. We would not have defender offices in each of the major cities. There'd be, or in the major counties. There would be, I think, district-wide offices. A good bit of the work that would be done out of some of those offices would be with the assistance of contract or rostered attorneys. I think Maine has a unique structure currently, and I think we could structure the defender services so that it would be more in the nature of a hybrid than a pure public defender operation throughout the state. And that's sort of the way I look at it.
Thank you. May I ask a quick follow-up?
Yes.
Sure. Commissioner Cummins, do you have any concerns about the loss of experienced rostered attorneys that, many of whom have been doing very wonderful work throughout the years with the establishment of a public defender's office?
No, sir. And I'd like to give you a direct and specific answer to that question. I actually think that the experienced rostered attorneys and attorneys generally will ultimately support this project, particularly based on the proof that can be generated through the Kennebec pilot. There was a period of time recently because of editorial comments at various hearings, that some of the rostered attorneys felt that they were not being appreciated. I think Justin has addressed this. I've spoken to those folks, and I think that's changed. We now have, for the first time, the support of the Maine State Bar Association. I do believe that, for example, when we set up Kennebec, to hire those 9 lawyers, we'll find that some of the most experienced rostered attorneys are likely to apply for that job.
Mr. Cummins,
So I think
you again are venturing into testimony as opposed to information for the work session.
I get it.
And I appreciate you wanting to fill us in, but we're kind of at the point where we're focusing on these initiatives. Thank you.
I did have a question, Madam Chair.
Go ahead.
Thank you. Thank you again, Mr. Cummins. Real quickly, is it your vision that the Kennebec County office would become a template if it's successful so that we could grow that model in other counties?
Yes, sir. And I won't proselytize beyond that.
Thank you.
Thank you for understanding where we are procedurally, Mr. Cummins. We really appreciate that.
I'm Irish. I can't help it.
Well, tomorrow's our day, right? St. Patrick's Day.
My birthday.
Wow. Okay, committee members, are there questions for Mr. Andrus related to Initiative 6? Senator Kime?
Thank you, Madam Chair. Mr. Andrus, I will be voting against this measure, but I do have a couple of questions that I would like to, first, I asked this before, and I think so just correct me if I'm wrong, the reason the decision was made to place a public defender office in Kennebec rather than Cumberland was because it was believed there would be cost savings involved with starting the public defender system in that area. Is that right?
So it is also my understanding, and I only qualify it that way because I wasn't present for the dialogue at the time. But as reported to me, that's largely true. Also would result in oversight efficiencies and sort of, I don't know what the right word for it is, but having the office present and co-located or nearly co-located would allow a degree of oversight of its development that would be more challenging if it were more remote. The office would be a little bit smaller. Kennebec County is a little bit smaller than Portland. The caseload's a little bit smaller, so there would be cost savings that way as well. The cost savings, when you look at the numbers, you have to think about, there would be a hybrid model, and so the Sixth Amendment Center staffing sense was based on an 80% caseload to the office and 20% of the caseload outside the office.
Thank you. And then my other question around the other two questions. One is I know that on the initiatives we're looking at, it says this should be broken down by personnel services, including positions and all other. So yes, is that located in another place? What all those positions look like? Because I know Mr. Cummins was just talking about how some of the positions would possibly not be needed there. Generally, we have all of that. And I have that question because Initiative 7, I have the same question about, so I thought I would just bring it up now.
Yes, Senator, if you were to look at
you want me to screen share that information?
If you could tell, is it in, I'm sorry, I have so many different papers in front of me. It's difficult for me to find where the correlating information is in this.
I can direct you right to it, Senator. In the volume.
During the break, that was something that Representative Newell had asked for right before we took a break. Should I screen share it?
I don't know who you're asking, Senator. I'm happy for it to be screened. It's page 15 of the compendium document is where I would direct your attention, Senator Keim and Senator Carney. If you were going to share that document, that's, I think,
Is this the one? Oh, no, this is the all other costs.
Of the large PDF I sent of all of the previous documents, it has consecutive page numbering so that we could have one consistent page numbering. At page 15 of that document, there's a breakout of the 11 positions constituting the Kennebec County Defender Office. And I think that's what Senator Keim.
Okay. Yes, exactly. Thank you for that. And then the way I'm voting today is really sort of as trying to prioritize funding and the things that I believe are most important to happen. And so that it's not that I'm not thinking these things aren't going to happen in the future. The other thing I guess I would like to ask you is factored into this, and maybe there isn't a way to factor it in, but obviously if we gave you as many million as, if we gave MCILS as many million as was asked for, there's a time constraint involved with just hiring people and then setting up an office. And then, part of what I'm concerned about, first of all, there's no way we have enough money to kind of pull all of this in at once. But even if we did, things have to be built carefully and slowly in order to be built well. And, I see you, with your limited capacity right now, and as we increase your capacity with extra help, being able to take on more and more. But I'm not sure that the numbers really reflect the fact that it would take X amount of months to build up to hiring this many people. Can you help me understand how you would, because again, I think I would have that same question when we look at Initiative 7. So just kind of wanted to get that idea out there right now.
And so just to make sure I'm going to answer the right question, how would we ramp up into either of the two public defender projects?
Right. So the ask, the amount of money associated with the initiative seems like it isn't actually possible to spend all that money in that year because we just couldn't hire and create all of these different offices on day one.
I think that's right, Senator. Thank you for clarifying that. So if I were left to my devices and these had passed or were to pass, I would still want to get some central office staff on board, redistribute the internal work, create some space in terms of my work and Deputy Director Maciag's world to be able to organize that. Then I would probably hire the first two out of each of the sub offices, the Kennebeck's office and the appellate office. I don't know if it's two precisely, but that's what comes to mind for me. And that's because I think two people brainstorming that project together is going to work better than one person in a vacuum. They're going to feed each other. And then those people are going to need to start to develop how it goes out. So we won't necessarily be starting from scratch. And I know this is not the time for the broad testimony, but I think everybody on the committee has heard me talk about ideas coming in from other places, including CPCS in Massachusetts. So some of the framework that might work pretty well, we can adopt, but there's still going to be work for people to do. And then there's the reality, as I think you were saying, that even if the framework were there on day one, not all of these people are hired and hit the ground running immediately. And so the reality is that it would have to spool up. Whatever we do will have to spool up, but these would have to spool up, and probably not all of that money would be spent because not all of those people would be working from the outset. And I think that is what you were, part of what you were asking me. Did I address your question?
Yes, you did. And I just don't know how it affects. So it most definitely affects the ask, right? If we're realistic about how much, I understand that when it's up and running, this is the cost. I just don't know if in the first year or something, if we were to try to make the cost reflect what we thought we'd really be spending, or maybe that's not possible with the budget, maybe, but certainly these numbers allocate more money than will be used in the first year.
I think that conclusion is certainly accurate, and I'm not sure that I can quantify it. And one of the issues is I don't know, and I appreciate the work of this committee. So we're one step closer, but I don't know what the resources are going to be. So it's hard to anticipate, for example, how quick central office spins up to allow the headroom to develop the program, to move forward with hiring people into the programs, to further develop the program. And so I don't, I can sort of imagine the algebra that gets that done, but there's so many variables, I don't know how to do it. But the conclusion that ultimately not all of that money is spent, even if the project is authorized, is certainly accurate in the first year, could even be accurate into the second.
Right. Okay, thank you.
Representative Evangelos and then Senator Sanborn.
Thank you, Madam Chair. Justin, I know that Mr. Cummins had earlier indicated that he would be willing to work for the commission in setting up this public defender's office on a pro bono or gratis basis, and now he's indicated that a nonprofit organization would help us. Have those two issues been taken into consideration in any potential cost savings?
In the budget, they have not, because I think we need to budget for the hard case. And I guess that goes back a little bit to Senator Kimes' question in terms of the budget number being what it would cost to do the thing, but the reality being there would be a ramp. Similarly, if Commissioner Cummins is available to lend his expertise, then that's great. There may be knowledge there we don't have to replicate from somewhere else. I do think it's really important as we think about this, though, not to rely on any cost savings that relies on even a dedicated volunteer. And I'm not in any way spurning Commissioner Cummins' offer to the commission, but at the same time, whenever a system is reliant on a gift, the system could be in trouble if the resources aren't there for it to work without the gift.
He did set up a public defender's office in Cook County, so I hope you'll take him up on whatever he has to offer. And then the other suggestion regarding the social workers and paralegals versus the trial assistants and aides that would help them, that would be a delayed expense if we went in that direction, because that second proposal would kick in until maybe November. Have we taken any of that into consideration, or?
No, I heard that for the first time at this hearing, Representative, that part of that idea. And I respectfully disagree with the nature of the people who would best support the office. At some point we can hash that out. This is again not the point for testimony, but I do agree with the proposition that some of the folks are not going to be hired immediately. So as far as that part of it goes, I certainly think that that's important. I do think that there are a lot of talented professionals in a lot of areas who are willing to come work for the state.
Andrus, I'm going to cut you off here just like I did Mr. Cummins, because we want to keep really focused on this proposal. And I know that Senator Sanborn has a question.
He answered
So
my question. Thank you, Madam Chair.
Thank you, Representative Evangelos. Senator Sanborn?
Thank you, Madam Chair. So I guess my question is sort of not to Mr. Andrus, but instead sort of to my colleague, Senator Keim. I think I hear what you're driving at, and I'm wondering if you might consider, supporting a public defender pilot project that starts in the second year of the biennium, so that the MCILS has time to spool up their office staffing with the first two initiatives that our committee unanimously supported, and then delaying the implementation of the pilot project, but not delaying it all the way out to a new biennium, but just pushing it out to the second year of this biennium, which may be more realistic in terms of the budget amounts, and also might have the ability to then cut that budget in half for this difficult biennium. So I'm just going to throw that out there as a trial balloon. I fully support the initiative as written, but I'd also love to get to unanimity on as many of these issues as we can, so that the AFA has that clear signal from us that we want to comply with the Sixth Amendment Center's recommendations. So I'm just throwing that out there. You may not be able to answer right this second, and maybe we need another round of caucuses at some point. But just wanted to make that proposal, given the timing issues that you raised, which I think are valid.
Senator Keim?
Yeah, thank you for that, Senator Sanborn. It is what I'm thinking, but in my opinion, we're not going to get both the appellate and the Kennebec defender offices. And I want to prioritize the appellate defender office over that one with my vote. But I have that same concern with that one, that we are asking for more than we can conceivably use, and therefore then sort of reducing our ability to get it passed. And so that's why, but I see that in both, but that's why I wanted to have that discussion.
Thank you for sharing that, Senator Keim. I think we can go in two ways. First of all, I would like to know if there are any other discussion on Initiative 6. And then I'd also like to know if once we've completed our discussion on Initiative 6, if we want to take a break for caucuses again. Senator Sanborn?
I was going to suggest, and I apologize if I'm out of turn, Madam Chair, but just that we discuss Initiative 6 and Initiative 7 and then go to caucus and then come back and vote on both initiatives.
That's a great suggestion that had crossed my mind as well. I'll just turn to you, Senator Keim, since you've raised the interaction of the two initiatives. Does that make sense to you as well?
It does, thank you.
Great. Okay, everybody on board with that? Not seeing any indications to the contrary. So let's, Representative Evangelos?
On the last initiative, we made motions before we went into caucus. Is that going to be the same process, or are we going to wait?
Yeah, we can have motions before we go into caucus, but I don't think we can have motions on 6 and 7 together. So I guess I think it will be a little easier for us procedurally if we discuss and then caucus.
And then motions.
And then have motions. So let's follow that.
Well, seeing that I'm an independent and I'm sitting here alone all the time, okay, I'll go along with it.
I appreciate your concerns and also your attention to the procedure. So first of all, is there any more discussion on Initiative 6? Representative Libby, wish to be heard on Initiative 6?
Thank you. Yes, I guess my question would be in regards to Initiative 6 and 7. I didn't know if Mr. Andrus could possibly speak to any kind of prioritization in his mind as far as which, if he sees a need greater in one or the other, or if that would be impossible because they're equal. Thank you, Madam Chair.
So in answering, I need to again distinguish answering in my perspective as executive director operating the organization as distinct from the commission who has put these as co-priorities. Recognizing the reality that we have to step up, my operational priority is that every dollar have the most utility and the broadest scope. And so that's why I was really happy to start with the back office stuff that was useful to all attorneys, all courts, all kinds of cases. And then with this, I would say the appellate office has both the potential to have a greater utility value by affecting cases everywhere. Also, it's probably a less troubling implementation avenue because there are many fewer moving pieces in terms of courts and different places it needs to be integrated into a different case assignment structure. The post-conviction side of that office would still be fairly complicated, but the true appellate side of that office, dealing with one court, the appellate stuff could be, the appointment stuff changes would be simpler. They would only happen one place. There'd be fewer people involved in the changeover. And so for both that economic efficiency and time and procedural efficiency perspectives, starting with the appellate office makes more operational sense to me.
Thank you, Mr. Andrus. And if it's appropriate, I just want to say thank you to Senator Sanborn for her insights. That was very helpful.
Senator Keim?
Thank you, Madam Chair. Following up on Representative Libby's comment, when you look at the appellate defender as well, are you thinking that we could kind of increase it marginally, like start a project, but maybe not? I think, again, maybe along Senator Sanborn's suggestion is that we can't really get all these positions in the first year. Is it possible to look at that and say, okay, in the first year, we could probably hire this many and then scale up to what would be the maximum? Is that something that we could figure out with you or no?
The answer is yes. Maybe a little bit more, maybe there's a little more teasing out of how that looks together as we do this. But the reason I can say yes easily to that is that starting with one appellate defender, one person in the office next to me could conceivably begin doing some appellate work. It's very different than a trial level operation with as much investigative work. I'm not sure I would say the same thing about post-conviction review. Post-conviction review is a strange hybrid that involves more on the ground factual investigation and some trial level work. But it would certainly be possible to begin with a tranche of appellate cases without necessarily diverting the entire appellate case flow, and then spin up more slowly. Where the efficiency in that is harder to say. I haven't analyzed it for where's the break point, or where are some break points for how many people and how many cases. I can think about that as we're talking, but the answer to the underlying question is yeah.
The other question I had around the appellate public defender office, like you said, it's going to be happening all over the state. And then when I looked at, the breakdown in this, I think it's assumed that there needs to be a brick and mortar location, but that I mean, obviously what COVID has taught us, but nonetheless, even without that, I think having a central office, a portion of central office overseeing the appellate makes sense. And I'm not sure, and I think it would be a great cost savings. Does that make sense to you? Can you see that as a possibility of a way to create this defender office in a more economical fashion?
I can. What I would want, I think, is to have some space somewhere. I keep pointing here because I'm in this big empty building. Deputy Director Masiak happens to be here, but almost never am I not alone here. But having a space where people can collaborate in person, because I do think that there's a synergistic, now I'm a bureaucrat, I've never used that word before. There's a synergistic effect of having people in the same place and able to talk and communicate. And so that needs to happen. Do they have to be here every day? No. When I love appellate work. When I was doing appellate work, ultimately come time to write the brief, and I would generally go sit in a corner somewhere and bang it out by myself. So that part, they don't necessarily have to be here. I do think that as it grows, like a unit supervisor should be here because they need to be in on some policy stuff sometimes and oversight. But we don't necessarily need to start out with everybody present. Doesn't save quite as much cost as I think I would hope it would, because a lot of the costs, like the OIT costs, are, somebody needs a laptop to go home with. It's the same device that they would have used in the office, but furniture, depends where we are. All these buildings have equipment in them, some equipment in them. So all these rooms, I'm starting to strike. So the answer is yes.
Mr. Andrus, before we proceed, I would love to try to time our caucus with your absence from our meeting. Can you remind me, did you say 3 o'clock is when you need to?
Yes, Senator, 3 o'clock. And so I would disengage 2 minutes before to make sure I can make the transition and then come back.
Okay, so let's, turning to the committee now, let's continue our conversation until 3 and think about that as the time that we would take a recess for a caucus. Senator Keim, did you have any additional follow-up questions?
I do. Can you help me? I'm not a lawyer, and so some of this all is just not firsthand knowledge for me, and I'm learning as I go still. But can you help me understand, again, you said that with the appellate public defender office that post-conviction maybe doesn't fit in so well with that. Can you just help me understand the difference between appellate and post-conviction and what you're saying there in the differences as far as how the office is run and set up?
Sure. And to clarify, what I meant to say is that the post-conviction review is more complicated. Ultimately, it kind of makes sense for them to be integrated in some extent. So on an appeal, you're looking to see, did the judge make a mistake? It's a little simplified, but that's the short version. And so typically on an appeal, you get the file from the lawyer who had it below, you get a transcript, you might get copies of exhibits from the clerk, you talk to the client, who on major appeals is generally in Wyndham or Warren, in my experience, more often Warren. And then you go and you do legal research and you decide whether you see things in this record that support a judicial error. And then you write a brief that says, Dear Law Court, Judge Andrus made a mistake when ruling in this way. That's the appeal. The post-conviction review, part of the process of that is analyzing whether the lawyer provided ineffective assistance. In order to do that, you really have to put yourself at ground level on the first day of the case and redo all the work. You don't necessarily literally rewrite a motion to suppress, but when I have a post-conviction review case, I get the original evidence, I get investigators, I get out and see what's on the ground, I actually go and look at the scene if appropriate, and you build that up. And so you're simultaneously building the case the way you think it should have been built and building another case that said the lawyer made a mistake in this way. And there's some other things, but usually that's what it is. And then that can lead to a trial where at the trial, you have to prove the lawyer made a mistake and that the mistake jeopardizes the integrity of the conviction. So that's much more complicated. The significance of it all to this conversation is you're dealing with all the different trial courts, you're dealing with prosecutors, you're on the ground, you're dealing with witnesses. It's a lot more it's a lot busier, many more moving pieces as compared to the appeal, where you could really hand me an appellate file and stick me in a box, and sometime later I'll come out with a brief. I need to talk to the client, but it's really much more simple.
Right, which I guess is why it seemed like you were saying that it was easier and you would prioritize appellate, but it seems like to me that post-conviction is so specialized that it needs that expertise. But maybe it doesn't matter because, now that we have greater standards in place for lawyers, or hopefully we do soon, that no one would be assigned to those cases unless they had that ability anyway.
So I think I was unclear when I was answering or trying to answer the question, could you spin it up slowly?
Yeah.
Also the question, does the trial level defender office or the appellate level defender office first make sense? And I said, in that context, the appellate makes sense because it's really plug and play. It doesn't really matter in a large extent whether the appellate attorney is an employee of MCALS or contractor of MCALS to the way the work gets done. Okay. That is what I was saying is distinct from the PCR. It's messier. It should happen, but it doesn't have the same ease of implementation that the appellate cases do as a priority over the trial level office.
Okay,
ultimately,
I understand.
Ultimately, it's highly specialized. Excuse me.
Okay, I understand. Thank you.
Thank you both. That was a very helpful interchange. Representative Evangelos?
Thank you, Madam Chair. Justin, regarding Initiative 7, would it be critical for the infrastructure of the Public Defender Office to be in place in order for the appellate defender, the appellate public defender to, become fully operational, or do you see that as something that could be done in isolation without the support of the office in general in Kennebec County?
Oh, I do not believe the Kennebec County office needs to exist as a predicate. I do think the structural planning for whatever trial level offices, Kennebec included, needs to be considered as part of the predicate. But the appellate office can't rely on the infrastructure of the Kennebec office in any way anyway, because of the conflict problem that exists. So that's why I answer that they're not necessarily interrelated in that way.
Thank you.
Representative Moriarty?
Thank you, Madam Chair. Justin, sort of a logistical question for you. What is the likelihood that a convicted indigent defendant says, I'd like to appeal, but I'd like to be represented by the same attorney who represented me at trial?
Likelihood? I don't know. I don't know the answer to that question. Practically speaking, we're getting, and I'm going to do my best to answer the question without getting too far afield. Number one, we don't have enough appeals. There should be more appeals filed, and they should be going to other counsel. Now, trial counsel has a continuing duty of loyalty to the client they had at trial. They should be cooperative and participating. But because, number one, there are issues that are cognizable on direct appeal that affect trial counsel, there's a conflict there. That's not generally how it happens, but it can happen. But more importantly, if there's an appeal from something that could be appealed even without an objection below, certain kinds of things can be appealed in that instance, you would now be relying on somebody who missed it below to not only catch it above, but also be willing to write a brief that said they messed up. And that's a conflict. Now, having said that, I have written briefs for clients. This has not been the practice. What I'm describing is what I think is the best practice and why.
Okay, I'll let it go with that. Thank you.
Committee members, our plan is we're discussing initiatives 6 and 7, then we're going to caucus, and then we're going to come back for motions and votes. Is there any more committee discussion on initiative 6? How about on initiative 7? How about on initiative 6 and 7 combined? Senator Sanborn?
I was just going to say, if we've got 5 more minutes with Justin, it might make sense to just understand what Initiative 8 is as well. And then we could come back from caucus and vote on all of it. And I think we had some questions and didn't really understand what Initiative 8 was.
Could you please address Initiative 8?
For reasons I don't know, fiscal year 21, MCILS was funded at $15.5 million, which is historically low for what it has been. And so that was what baseline carried forward. Initiative number 8 effectively establishes the historical baseline by undoing whatever caused that to be low. And I'm sorry I can't answer the whatever it is. I hate not knowing that, but still lots of things I'm learning. But that's the answer. That's why it's there, and that's how it works. I would also, may I interject something, Senator?
Yes. Well, first of all, let's see if there's any follow-up from Senator Sanborn on the baseline funding question.
So I just wanted to restate that it's basically just grossing up your baseline budget to where it historically had been the year before, because you weren't sure as to why it had been indicated to be a lower number. Is that a restatement? Okay.
And then you can go ahead, Mr. Andrus, you had something else that you wanted to observe?
Just that there were some things at the end of the memorandum, and I know I don't have the prerogative to direct the committee, but I would ask that after the caucus and we all come back, that we can also look to some of the things that are at the end of the memorandum in terms of the legislative changes, just so that we talk about what's necessary to implement some of what we're talking about.
Yeah, we haven't forgotten about those, and I'm glad you reminded us as well. Okay, so we have about 2 or 3 more minutes of your time. Are there additional questions for Mr. Andrus before we take a break?
Madam Chair?
Yes.
Yeah, could I ask Mr. Andrus again, if A plus B equals C, and B in Initiative 8 is the 2.8 million, what actual numbers did you use for A and C?
If A and C,
if the 2.8 is added to a number to get what you said is the norm, what specific numbers are you using? If you could help me with that.
I'm very sorry. I'm trying to.
I think I might be able to answer that. So this is Initiative 8. And I believe the concern that was raised is that for FY20, the baseline was much higher than it was for FY21. And so the 2.8 million is the difference between fiscal year 20 and fiscal year 21 funding for the organization. Is that correct?
Yes.
Okay, great. Senator Keim and then Representative Libby.
Thank you, Madam Chair. So I guess I'm not sure how we go about this, but when I look at the Appellate and Post-Conviction Review Office and the staff that's in there, is there a way we can vote for that partially? Knowing that we can't have it all anyway at first, it just doesn't make sense to try to push through something that large. But is there a way to vote for it partially? Can anyone answer that?
Is that a question for Mr. Andrus or for the committee?
Yes.
All right. Mr. Andrus, why don't you take a gander at that in the moment that you have, and then we'll caucus and maybe we can talk about that during our caucus as well.
Thank you. And if you'll forgive me, I'm going to add one other piece of information to this answer. So from my perspective, the office could work with fewer people if the expectation for the caseload density it was going to take was adjusted accordingly. And so it's roughly expected to take roughly 80% of the volume. That's comes from the 6th Amendment report, and it's been carried through that sort of expectation. And so we could conceivably hire a quarter of the people and do a quarter of the work without substantially impacting the efficacy of the people doing the work. The efficiency would be okay. I did say something that I think I want to correct, though, just to be sure I've been clear. And one of our commissioners brought this to my attention. And his priority, and this is not Commissioner Cummins, his priority would have been for the trial level, because the standard on review requires a demonstration of error, and it's problematic sometimes to succeed on appeal because of the way the appellate structure works. And I would express that it's really important to get things correct at the trial level as well. And although in answering the question how to be most efficient, I'm comfortable with my testimony and my perspective as executive director, I did want to offer you that opposing view from another commissioner, which is of course consistent with Mr. Cummins' Mr. Cummins' testimony. Thank you for that moment.
Thank you. And at this point, I think we need to respect Mr. Andrus's time commitment.
Yep.
And let's plan on a 20-minute recess for caucuses. And if we need additional time, we can do that. And Senator Keim, I'd like you and I to chat for a moment as well. Representative Babbage, did you have a question?
Yes, please. I intend to vote in favor of.
Can you save that for after?
No, because I need them to think about something, and so that I can direct my vote appropriately. I'm just wondering. I wanted the committee to consider, if they are thinking about voting against Initiative 6, would they, in an attempt to make a unanimous statement to AFA, I'd be willing to vote for second year funding. I would just like that to be part of the conversation if somebody is thinking about hesitation to vote affirmative. Thank you.
Thanks for sharing that. Okay, everybody, we will reconvene at 3:20. Thank you.
And if I could, I noticed that Representative Evangelist feels alone, and I just want to officially welcome him to the Republican Party if he would like to join us. Not on our caucus, he can join. He can join our party. And Senator Carney, if you want to call me, I need you to do that on my home phone, if you could.
Yes. I don't know that I have that.
I'll give it to you. It's a public number anyway, so it's okay if it's out there in the world. It's 562-6023.
Thank you. I'll call you shortly.
Okay, thank you.
And just remember to mute and turn off your video. And Representative Evangelist, did you have a question?
Yeah, nice try, Lisa.
See you all soon.
Hi, Representative Evangelos. I think they're not coming back till 3:30. Hello, I just heard that I think they're trying to reconvene at 3:40. Nice to see you, Representative Hagan.
Great
Did you
seeing
hear?
you also.
Great.
Okay, 3:40
Nice to
sounds
see you,
good.
Representative Libby, and Representative Angelos too. Yep,
All right,
3:40.
3:40. Toodles.
Thanks. Hi, Senator.
Peggy.
Did you hear that they're reconvening at 3:40? Okay.
Yeah.
Just want to make sure.
13, 16.
Chris, you're not on mute. Oh, now you are.
Mic's on.
Thanks for all your patience, everyone, as we did a lot of work during the break. And I'll just give committee members a couple more minutes to rejoin us. There's a few missing. Okay, so we're back from our break, and the process that we're going to follow is a little different. We're going to vote on initiatives 7 and 8, and then we're going to take another brief break before we return and vote on initiative 6 and do a few little housekeeping things. And so we've had a pretty thorough discussion of initiative 7 already. And Representative Evangelos, did you have a question?
Thank you, Madam Chair. Yes, I want to disagree. I don't think we should vote on initiative 7 until we handle initiative 6, because I've heard from at least one of the commissioners and they feel very strongly, and it's not Mr. Cummins, just so you know, I know he'd agree with me too, but it's the errors that are made at trial come at the original trial. And that's what causes the reason for an appeal. So if we can't handle initiative 6 first, it seems like we're putting the cart, before the horse. So I think we should do them in order. It's just me again, dissenting, but I'm not real pleased the way these discussions go outside the view of the public with these caucuses. It's the process that's followed up here in Augusta, but this whole discussion should have happened in front of the public so that the commissioners are aware of what we're talking about. And I'm prepared to make my motions if I'm recognized. Follow the process you want. I just think that an appeals court on an appellate defense comes after your first trial didn't go well, and we're talking about ineffective legal counsel. And how are we going to get to fixing the ineffective legal counsel until we address initiative 6?
Yeah, just my thought to vote on 7 and 8 is just because I have been very busy and I haven't made up my mind about 6 yet. And I want to have a little bit more time to think about it. And so, and I appreciate the feedback that you've just provided. But it's not because it's not important. It's just because we're all busy and working hard and trying to do the best we can for the people of Maine right now. Senator Keim?
Thank you, Madam Chair. I appreciate that, Representative Evangelos, and I think I was maybe reading the same email that you were, and I understand what's being said, and I agree with it to an extent, but I think that's why we're setting up new standards for the lawyers, so that we're making sure that even if they're by contract and being paid by vouchers, that we are improving the standards that these people that the lawyers have, and who is representing the people of Maine. So I am confident that that is our intention, and that is what's going to happen, is that the standards are going to improve, and that we aren't ignoring that need by saying that the appellate is important and rising that to another level. For me, it's more about the fact that it's a specialized type of representation. And I personally feel, I have heard from a number of lawyers that the oversight, the greater oversight and the centralized ability for the lawyers to work together on this type of thing and learn from each other is important. And so that's why I have come down to my decision of looking at, as valuing this one higher than the other. Not that they aren't both important. And I certainly do not mean to portray that I think it doesn't matter that we don't have good lawyers at the first go round and representing people. I just think that it's important. I think that this makes sense to have a central location and for this to be handled. And I've also heard from a number of people that upcoming, we will have quite a number of possibly of appeals because of the amount of time the courts have been shut down. So I think this is also very timely with the COVID shutdown that we've had. So I understand what you're saying. come down to a different decision on it, but I don't disagree with what you're saying either. And I can talk about where we've come as a caucus with Initiative 7 if now is a good time, Madam Chair.
Are you prepared to make a motion?
Yes.
Go ahead.
So as we talked about the appellate public defender office, recognizing that it takes time to build any organization up to full capacity. And also based on what Mr. Andrus said about having, initial start of 2 people who work together and collaborate and figure out, best steps of how to grow and move forward. We wanted to make a motion of 2 positions to start out in 21-22, and then to be increased to 4 positions in 22-23. With the addition of a sunset on those recommendations. And the reason for the sunset is just that I think a long-standing problem at MCILS is not enough oversight. We've expected for a decade that it's just that somebody's handling it and it's happening and it's going well. So, the sunset provision was a suggestion of one of the caucus members, and I completely agree. I think it gives the Judiciary Committee, whoever is there at that time, to have a feedback loop and to listen to what's been happening and to reevaluate. So that is the motion that I'd like to make. And then I did have a chance to speak, which is again why our time went a little bit long. But I did call Mr. Andrus and asked him to walk through with me. So if on the large document that's like 43 pages, the positions outlined in Initiative 7 are found on pages 18 and 19. And I asked him to look at those and tell me what the first 2 positions would be, and then the 4 positions. And so on page 18, it would be the Public Service Manager 3 with an associated salary of $102,000. And then on page 19, so for that first year, it would be a paralegal with a salary of $40,643. And of course, benefits are on top of those, but I'm just listing the salary amount to help you see which positions are being discussed. And then in the second year of the biennium, it would be added 2 lawyers, and they would be public service manager 2 positions, both with a salary of $70,000. And and just to make note that, as is talking with Mr. Andrus, obviously what the commission's asked for and based on the 6th Amendment Center report, he is advocating for all of this. But as we are the legislative body that gets to make the decisions on funding, and it's our vote that eventually makes these decisions. And so the reality is that it's a tight budget year and we need to move forward. I think it's incredibly important to get started on this. And I believe it's important to offer something to AFA that is practical and has a better probability of getting their vote and getting the money. And so that's our reasoning behind this this proposal. And that's my motion, which is very long.
Could I just raise 2 clarifying points, Senator Keim? First of all, thank you very much for that motion. I've been thinking about the sequence for the report back and the sunset, and thinking that the report back would be on December 1, 2023. So that would give us the full biennial with the program in place, and that the sunset would be 7/1/24. And again, that would give the legislature time to accept the report back and decide and evaluate the program and decide whether to repeal the sunset. If, as I'm dearly hoping, the program is a success. I mean, this is one of the great things about this approach is that it is building something that has the potential to be a permanent part of the way we provide legal services to criminal defendants. And it's exciting to start to really build in that direction. So would you accept those suggestions?
I do, absolutely. That absolutely makes sense. Yes, thank you for that.
Thank you. And do we have a second on the motion? Representative Libby? Okay, so moved and seconded. And is there discussion on the proposal among committee members? Representative Evangelos?
Oh, thank you, Madam Chair. Do we have a dollar figure associated with these two proposals for each fiscal year?
I'm looking to our analyst
Roughly.
and wondering, Peggy, if there would be a way that we could do sort of a language review type undertaking tomorrow.
Well, I just want to know a guesstimate. We're talking about 2.6 million and 2.6 million. What are we reducing it to? Around 400,000 a year, roughly? I mean, does that sound anywhere near the ballpark, Peggy?
Well, I'm not sure what the all other is, but if I understand what was just proposed, it was 2 positions in year 1, which would be about 150,000. Not including benefits, whatever the salary was 150,000. And then the second year would be an additional 140.
So the proposal is 2.6 million cut to 200,000 and 2.6 million cut to 200,000. And then apparently from what I'm hearing, you're going to hold another caucus so nobody can hear what you're talking about to discuss initiative number 6. I mean, here's my concern. You know, I've been following the discussion out of the Criminal Justice Committee, and, you know, I see what's going on with MIAC and everything else. The police state in Maine never goes for a lack of funding. They get everything they want. They even, you know, Senator Carney, they get armored personnel carriers they have to gas up. You sent us a picture on one of the police shootings. We're talking about defending poor people here. And it's a top priority, not something that we should be slashing by 80%. I don't want to walk back on the work we've done. We're talking about an $8 billion budget. I don't have my calculator with me, but 2 million is what percent of 8 billion is a decimal of a decimal of a decimal. I know you're trying to broker a compromise, Senator Keim. I appreciate, you know, the whole problem with the way we operate up here is that we try to operate through unanimous reports and unanimous consent, and that's half the time why we get nowhere. But I feel like I'm being forced to compromise my values. And my feeling that this is such a milquetoast, a huge cut in what was proposed. I thought we made them a commitment that we were going to fix this thing. We have a constitutional crisis. We're going to get sued. I know we're trying to start, but it's hard for me to weigh in and vote on this without knowing what you're going to come out of your caucuses with Initiative 6s. It's really hard, I got to tell you. But you know, those are my feelings.
Yeah, I appreciate how you're feeling, Representative Evangelos, and I don't disagree with you. Much of what you say, I'm looking at how we can do the most good with what is available from a resource perspective. Representative Libby was next, and then Representative Harnett.
Thank you, Madam Chair. I completely understand the Representative Evangelos' point of view, and I do sympathize. I would rather that our committee make priorities than the Appropriations Committee. And that's where I'm coming at this from. I think given our understanding of the issue, I would rather not send the entire, 8 initiatives and have them just slash whatever costs the most. I would rather we be able to make reasoned choices about what we're presenting them so that we can hopefully get as much of that as possible. That's my reasoning.
Thank you. Representative Harnett?
Thank you, Madam Chair. And this is a question for Senator Keim. I just wanted to make sure I'm following the positions. I'm looking at pages 18 and 19 that you referenced. And am I correct that the first position, which would be in the first fiscal year, is at the top of page 18, right? And the second position is the paralegal position towards the middle of the next page on page 19. Then you hire 2 attorneys in the next year. Am I correct that you're hiring the lowest level attorney possible there? Because not anybody with, they're going to be low on the experience level.
Right. Mr. Anderson and I did discuss that, and so maybe you prefer to hear from him, but that his thinking is that they would be trained by the higher level attorney and then moved up as we grew the system.
Okay, so that classification was discussed and you'll address that.
It was discussed, and I noticed that he put in the notes that he has numbers if we wanted the numbers, and it is pretty easy to add the salaries and benefits, but where the numbers get a little more difficult is of course the extra costs, like figuring out office supplies and all of that. I don't think it's possible for us to figure those numbers today, but we could have them maybe whenever Peggy gets them to us.
Thank you. That answers my question.
Are there other questions on part of committee members before we take a vote? Representative Moriarty?
Thank you, Madam Chair. So just to clarify, in the first year, we have 2 attorneys, 1 paralegal. In the second year, we have 4 attorneys all told, and I'm not clear as to how many paralegals.
Let me do this. I am going to ask Mr. Andrus to summarize where we are, because he also has the dollar figures that Representative Evangelos wanted to know a little bit more about. So Mr. Andrus, could you please describe for us the positions, the salary and benefits, and then your feeling about the proposal?
Yes, thank you. And as before, for clarity, the commission's proposal remains what was submitted in October as backed. And I need to say that because I think that's an important distinction. I'm doing my best to serve this committee by providing this information. I'll continue doing that, of course. If the committee determined that it would build out the appellate office in 2 people and then 4 people, then I would recommend that the first person hired be the person who will ultimately be the director of that operation. They are a public service manager 3 attorney. The salary level would be at step 3 for their grade would be $102,000 with fringe of $62,000. I'm rounding to the nearest thousand. And then to support that person, the second person would be a non-attorney staff member, paralegal. Salary would be $4,600 and fringe would be $38,000. My quick math based on the all other costs associated with that office would be there would be first year all other costs of $21,064. Those people could both do some actual appellate work and spin up the rest of the program. That's what I would do if I were offered 2 people in the first year. If I were offered 2 additional people in the second year, what I would do with them is I would have 2 lawyers doing direct client work. They would be the assistant appellate defenders, and they would be entry level with the idea that they would train in and they might apply internally if the program got built out further to one of the more supervisory roles based on their experience. Each of them would be public service managers 2 at grade 31. They would be starting at $70,700 and their fringe would cost about $50,000. once we had those 4 people, the total employee cost for fiscal year 23, and I wasn't smart enough to put in the 3% raise. It's very slightly low. It's 484,171, and the all other costs would be about $42,000 for a total cost in the second year for those 4 people of 526,307, which is beyond the significant places, frankly, of the rounded math. So forget the last $307. But that's about right. 242,917 plus 21 equals 263 in the first year. 484 plus 42 equals 526 in the second year.
And do you think that you could meaningfully evaluate the program and provide a report back by December 1, 2023?
I'm concerned, and I'm still learning about how the whole budget cycle works. I'm concerned that putting that date there means that you're past the submission date for the next biennial, and that things get complicated. Okay, all right, just making sure. So, but yeah, certainly with those 4 people, we could have a look at the efficiencies and quality associated with having employee attorneys servicing appellate cases, and whether that's perfectly capable of extrapolation, I'm not sure, but I hope it's useful data that we can then support the whole program. And I mean, I just, in doing this is the most work with the fewest dollars, not the prioritization of these roles over other roles in terms of the effect they would have on clients. If you could give me the budget, I understand the problem. If you could give me the budget, there are other ways we might go. This is with these 4 people, a plan that really gets us somewhere.
Right. And we do really appreciate the role that you have here, where we as the policymaking committee who are voting on a biennial budget report, we are making compromises. We understand that, you know, in this case, your position and the commission's position is to fully fund that initiative. Much like with Initiative 5 with the hourly rates, that is a compromise that we as the committee came up with, again, in an effort to do our work on the biennial budget. And we understand where your position is, and you've been really clear, and we appreciate that. We're just in a different role vis-a-vis this work than you are. So thank you for your responses. Representative Babbage, did you have a question?
Well, being a work session, I have a comment.
Thank you. I tried to swallow that word as it was coming out. Do you have a comment?
I appreciate all the work that's being done here. I mean, the senior lawyer, according to the figures I'm looking at, would be about 164,000 with benefits. The paralegal, 79. Each of the 2 second-year attorneys at the lowest level would be 70 plus fringe benefits, which is 120 apiece. I came out with 484. I mean, even if with the 3.2, it's going to be $500,000. My point about that is I'm not sure if the 14 positions and 6 staff, 14 lawyers and 6 staff that would have gone along with them with the full boat is where we need to be. But I am disappointed that we're only at 20% of that with this proposal. But I understand it's a foot in the door and certainly an improvement over the status quo. So I understand Mr. Andrus's, I don't know if I'd say enthusiasm, but acquiescence here. But I'm disappointed with the dollar amount. That's all I'm saying. I would prefer a better assessment of how this is going to look going forward by funding it to a higher level. That's my comment.
Thank you for those comments, Representative Babbage. Senator Kime?
Thank you, Madam Chair. I would just, in response, Representative Babbage, I understand what you're saying, but we're obviously still going to do the work. You know, it'll just be through the voucher system rather than a public defender. So, I mean, people will still get represented. And hopefully I like the foot in the door, and I'm hopeful that we learn from this the benefits of a public defender, and it's just an easier ask. And you know, we're up against it. It isn't just what our committee thinks, it's that the governor didn't even put any of it in her budget. And our ask in the supplemental budget was ignored. So, you know, we just, the practical matter is, I mean, and even their baseline budget was decreased. What is that about? That's a financial gimmick. So for me, this is about being practical and trying to ask for something that's realistic and moving towards what I think will be meaningful change.
Is the committee ready for a vote? Representative Harnett?
Thank you, Madam Chair. And I'm trying to collect my thoughts because these are the difficult decisions we make when you're voting for something that you're not entirely happy with. And I want to build on what Senator Kine just said. We were brought a budget by the chief executive that not only flat funded this program in the face of the Sixth Amendment Center report, but took money away from them. If we restore that money and we move forward with the initiatives that we've already approved today, we're putting, and my math is rough, another $14.4 million into our defense of indigent legal services, of indigent legal defendants. Is it enough? No, it's not enough. But is it something that we might be able to move forward with AFA? I certainly hope so. I worry if we just come to appropriations and say, we want it all, you make up your mind. We're not going to get what it is we think is the most impactful dollars being spent the way that we would like them to be spent. So I'm not happy with this proposal on Initiative 7, and I respect Representative Babbage's comment that it's roughly 20% of what we asked, and I understand Representative Evangelos's comments, and I know we will hear when we speak on other matters that we're balancing the system on the backs of our poor folks, our poor criminal defendants, and those who are subject to a loss of liberty in other criminal proceedings. I guess that's a very long-winded way of saying that sometimes I have to vote for practicality and not for everything that I think needs to be done. So thank you.
Representative Evangelos?
Thank you, Madam Chair. I actually did find a calculator, and the ask by Justin and the commission in this proposal here amounts to 3/10,000ths of 1% of an $8 billion budget. And I just philosophically, along the lines of what Representative Harnett and Babbage have said, we wouldn't even be having this argument if it wasn't about poor people. It would just get funded. I don't see that we turn down any positions the Attorney General's office or the police ever want. They get everything they want every time, right up to the armored personnel carriers, Madam Chair. I just think that, we're sitting on the risk of being sued, and then we come up with I don't know what's going to happen with Initiative 6, so maybe you haven't heard anything yet, but this isn't what I wanted to do, and not happy about it. I hope that guys don't go into another caucus and talk out Initiative 6. I hope you'll do that one in public. I'm really having a hard time with this. Seems to me highly discriminatory against an underclass of people. I think that hearing we held with the commission clearly demonstrated that we've probably got some innocent people in prison, and I want to fix this. And I know Mr. Carroll has spoken forcefully, and Mr. Cummins and others, and I just feel like I'm betraying my beliefs, it's difficult for me. This is small ball, the money we're asking for. It's peanuts on an $8 billion budget. And I don't see anybody ever struggling like this, funding the police, all the stuff they have. Just really struggling with this. So there's a motion on the floor, so I'll wait for number 6 to make my motion, I guess. Thank you.
I think the committee is ready for a vote. Thank you, Ms. Panett. You can go ahead whenever you are ready.
Thank you very much, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Sorry about that. Yes.
Thank you. Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Am I allowed to abstain?
I don't believe so. If you have a conflict,
Pardon?
Peggy, you,
Take a walk.
Peggy, you're muted.
Sorry, you could have a minority report, which is, more if that's what you wanted to do. But I don't think the committee rules actually let you abstain if you're in the room. If this is in the
Okay,
room.
well, I'm going to vote as a minority report. I'm going to vote, I guess I'm going to vote no. My minority report is to fully fund both years, as was outlined in Mr. Andrus's proposal. Sorry about that, folks.
that will be a no.
That's a no minority report for full funding.
Thank you. Representative Evangelos votes no. Representative Newell. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. I have 10 members voting in the affirmative, 1 member voting in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. Now we'll move on to Initiative 8, which is an initiative that returns the baseline funding to the amount of baseline funding prior to fiscal year 21. And so the difference between the current funding proposal and the higher baseline is what's represented in the line items of roughly $2.8 million. Senator Sanborn?
Yeah, thanks, Madam Chair. I just wanted to speak to this item and say that, I think in the face of the lawsuit that we're facing and in the face of the Sixth Amendment report, the idea that we would be trying to shave money out of the baseline budget and not level funding just doesn't make any sense. So I'm not interested in doing that, and that's why I think this initiative is a good idea and why I plan to vote in favor of it.
Are you making a motion, Senator Sanborn?
If you'd like me to, I'm happy to. I would move Initiative 8.
As written.
Is there a second? Representative Harnett?
Second.
Thank you. Is there any discussion? And I'll recognize you first, Representative Harnett, since you already had your hand up. Oh, we're not able to hear you.
I'm okay. Thanks.
Okay.
That was up for the second.
Thank you. Committee members, is there any discussion of the pending motion, which is to approve Initiative 8? I am not seeing any discussion, and so Ms. Panett, we are ready to vote. Thank you.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. 11 members voting in the affirmative, 0 in the negative. 3 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. We are going to take just a very brief break at this point. It's let's come back at in 5 minutes, if that's okay with everybody. Thank you.
Hey, Peggy. Did you read Joan's email?
I did. You know, everyone's hearing us.
Oh, I know.
Yes. Yes, I did. Amazing.
Hello, Representative Evangelos.
We playing tonight?
Yes,
Pittsburgh, right?
yes,
We at home or
we are. You were in Pittsburgh last night. We're at home tonight.
still no fans though, right?
In Boston, there were fans in Pittsburgh.
Were there? How many? Well, I mean, 20%,
Several,
several, about how we just funded Initiative 7, about that percent.
just about. Just about.
Do they do the cutouts in the seats like they do for,
No,
like they did?
they cover the seats with like just
Oh.
solid cloth, canvas. I don't know.
It's a hockey game, Peggy. The cutouts would start fighting.
So when my daughter was young, we took her Girl Scout troop to, I guess it was the Mariners, and they had these great seats right at the corner, really low down. And there was a fight, of course, but they had to stop the game to scrape the blood off the ice.
Oh, that's bad.
That level of hockey is a little bit more because they're trying to make don't you think, Jeff, they're trying to make a name for themselves and bring them up. That's
mean
remember the movie?
AHL, you mean, in the minor leagues?
Yeah.
Yeah,
Remember-
well, you got to do what you got to do to get up there.
Well, you remember the movie Slapshot, right?
Yeah, with Paul Newman.
Yeah.
Well, they don't make them like that anymore.
No.
They wouldn't even
No.
put that on TV today.
The guy that played the bad guy with the really curly hair, he went to Bowdoin, Eddie Dowd.
Really?
Yeah.
Me.
And it was his sister that did the screenplay. Nancy.
Wow. I didn't know that.
Yeah, it's really kind of loosely based on his experience because he was at Bowdoin, he was kind of a star. But, Bowdoin is not BU or BC or, the big schools.
You're on mic now.
Oh, sorry. Nothing against Boston. I mean, I
People just heard you. Susan Panett, she lives in Brunswick, gang.
I'm not criticizing Bowdoin. I love Bowdoin. That's my. You're going to get me in trouble with my hometown.
You got yourself in trouble on that one.
Uh-oh. Well, it's true. I mean, they're ECAC Division 3. Stop. Be good. I'm leaving.
So are you planting already, Jeff?
I planted my peppers and my onions under my lamps. Yep.
Oh, okay.
So
Nice.
yeah, I started those Sunday, and then I'll, I've got a schedule I do every year. In a couple of weeks, I'll get everything else. Just so you know, this is on mic. I use 4-foot fluorescent shop lamps. They sell for $13 in the hardware store. I've done it for 35 years. And you get the simple T12 F40 cool white bulb. They're only about $3 a piece. The plant bulbs are like $20 a piece.
Yeah, right.
The cool white bulb is the same light.
Really?
Mm-hmm. Yeah, and I had a greenhouse operator tell me that 35 years ago. He said, don't buy the plant light, buy the cool light. It's the same thing. It's all about merchandising and marketing on the plant light. And those lamps you just pay $13 for. I've been using the same ones for 35 years. They never break, and you never buy a new bulb because they last a long time. So I know what it cost was I wanted to add, I'm going to plant more this year, so I'm going to add another lamp. So I have a string of 6 or 7. So I bought one last week at the hardware store. So for less than $20, you're good to go.
Representative Evangelos, we have a Bruins fan out there that was listening to us.
Oh, who's that?
I can't mention.
Did they write you? Did they write you? Did they write you? Yeah.
We just got an email.
Yeah. Well, that's good.
But this person's a Bruins fan, so that's good.
That's good.
Peggy, we just got a new confirmation.
Another one? Yeah.
Seriously?
Yep. Human rights.
Okay. Must be the Republican nominee then, right? Waiting on one. Did you hear about the Patriots yesterday?
Yeah.
7 really good.
Bill's going crazy with the money. He's just
Yeah, he is
tossing it
crazy.
around.
On a bender. I love the players he signed. That guy from the Ravens is an all-star, He has 9 sacks. They addressed a lot of needs. 2 wide receivers. It's really looking good. I'm gonna confess I'm getting back into the sports, after what we went through. I thought that,
Knew you'd pull you back. We'd pull you back.
my wife and I were sitting there and I said, geez, we haven't been watching sports because everything got suspended. And I thought we didn't miss it, but we did. I'm enjoying it.
Oh, somebody just said I did Bowdoin slander. No, I did not.
You did.
I love Bowdoin.
I tried to stop you. Let's see. I think the appellate public defender may be able to help you with it.
I'm a Bowdoin brat. I'm leaving my house to Bowdoin. Now it's all out there. Uh-oh.
Yeah, I have several people telling me that our mics are on.
I know.
We know.
We're doing it on purpose.
This is our own little caucus.
We don't want you to feel left out, Representative Evangelos.
I don't feel left out. I wish they'd abolish that form of governing. It's not okay. Everything in secret. I hate it. Sorry. Remember, there were a couple times last year in judiciary, it was my bill. Remember, they wanted to go out and caucus, and I said, no, you got anything to say, let's say it in front of the people,
I have to write a message to Tina.
Yeah.
Guess I'm just not cut out for this anymore, Peggy.
Jeff, you're a mainstay.
The good thing about my little independent caucus here is there's never any disagreements.
Always unanimous.
It's always unanimous report.
Very thoughtful. Always well reasoned. Yep.
Anyways, I've been hearing that both of you have been just working extraordinary hours. Peggy, I know I'm getting emails from you on Sundays, so it's tough stuff right now. And
But,
thank you.
you know, you're welcome. Thank you. I know you're working all the time, even if you're not in meetings. So,
You know, it's hard because of the way we're operating. Luckily, I wake up involuntarily at 4:30 or 5. So that's when I clean up my emails every morning. So in fact, I don't have my inbox is every single one of them's been, I don't have any outstanding ones. So, but on the other hand,
that's an accomplishment.
5 or 6 o'clock at night, I shut it down. I just no more tonight. You got to have a little time for family.
Yeah. Yep. And I usually don't look at my email after 8:30. Maybe it's 8. Depends.
That's at night.
At night. Yeah.
If this was any other line of work, we'd be filing unfair labor practices.
Yes. Yes. You know, the Fair Labor Standards Act does not apply to legislators or their staff.
I actually looked at that a couple of weeks ago when they found out that they weren't going to even buy us our computer toner ink, and, from working at home. So I've been coming up for most of our sessions because my aide is here and he's a tremendous assistant. He's like, for instance, today he was making copies of the new budget and stuff like that. It's so much easier for me to look at it on paper and make notes.
Right. Right. Yeah. No, you have outstanding staff.
Yep. I miss Soupy's files though.
Oh, I bet you're going to say the snacks.
I miss all the work you did for us when we met in person.
I know.
Oh, you're talking about the
I
food?
miss it too.
Wasn't really snacks. It was more like hors d'oeuvres, high-end hors d'oeuvres.
Oh, that's nice to hear.
Oh,
Well,
everything was high end.
I'm still collecting recipes for next year.
You should ask all the committee members for their $20 like you did before, except for you're not going to have hors d'oeuvres this year.
Just wait till January. It's going to be so wonderful.
And I take requests.
That's right. Did you figure out everybody's birthday and their favorite colors and their pets?
No. Not really.
I worked outside yesterday for 3.5 hours. And
It was so windy.
I know I only had blue jeans on. I didn't put any, thermal underwear on, and oh, my legs were a mess. They got all frostbite. My wife nearly killed me. I didn't know it until I got inside and took a shower. Then it started stinging.
What are you, a 4-year-old?
I don't know. A 4-year-old would do better than that. They'd
No.
listen to their mother.
Maybe. No, see, my experience with kids is they're never getting cold. They're fine. And then all of a sudden they're cold.
Yeah.
There's no transition.
No. Well, I wasn't cold because I was working in the woods and stuff. And, I did legislative stuff all morning, but around noon, I just wanted to get out.
How's Sheba?
She's good. Yep. Doing well. I got her all new sawdust in her stall yesterday. So I knew these cold days were coming. So make sure
Soupy, I missed Pi Day.
I know. I saw that yesterday.
Yeah.
We'll just have to have double pie next year.
Sounds good.
Lisa, she's still asking for her $20 and we're getting no snacks.
Oh my gosh, I knew it.
She's earning interest though. It just makes the pool bigger.
I happen to
Great.
have the Facebook page people out there that know that that's not true.
Yeah, that was a lie, a big one.
Yes,
But
thank you.
for the new members, you can't believe the quality of food we get. I mean, it's just not like regular stuff. It's excellent. All kinds of fruit, high-end cheeses. Wouldn't you say,
And
Lisa?
Pie Day. We missed it.
Pie Day, yeah.
I'm sad to be missing out on, it sounds amazing.
Big
So
time.
we'll just have to double up, you know, in Representative Down, she'll just have to stay with us.
That's right. But you do know that once you're a member of judiciary, you're always a member of judiciary. So
That's right.
you never really leave.
Oh, by the way, point of order. Didn't I hear Senator Carney's cell phone go off this morning earlier?
I like
Peggy,
it.
come on.
$5.
You hear it? I heard it. That's $5, right?
I hear all sorts of things.
Yeah. Well, we had a rule that-
Oh, I don't, yeah, that's not good.
I heard it. I'm the only member who's never paid.
Because you don't have a cell phone.
Correct.
Yeah, I've paid in once or twice.
I have not heard about this. I'm trying to think of where that, let me pull my rules out. I'm trying to figure out where this is in the.
It was in the rules.
All the fun, we're missing out on all the fun stuff, and we don't. Oh, and listening to Justin Andrus talk about how he wanted people to be all together so they could talk, and I thought, wow, what a novel idea.
Right. Right.
It was nice seeing everybody last week. You know, until it went past 9 o'clock at night. But it was, you know, it was just nice connecting with everyone again. And I truly miss the people. It is, you know, it's a people business, right?
It was nice. And Jeff, you have a very convenient seat for stopping by to say hello.
Yeah.
Right
but-
there by the exit.
Notice where they put the independents. We're called back
We're
benches.
escaping. He can escape too.
You guys are super easy to access. Hey, Jeff.
So
Anytime, Jeff, anytime. You don't want to be alone anymore. We welcome you.
I heard it before, Lisa. Nothing under advisement, but it's hopeless. Just nice talking to each other.
So we once had a huge hearing at the Civic Center, and I don't know if anybody's on the committee still other than Soupy and me, where they had to evacuate because the popcorn in the concession stand caught on fire.
That's because somebody wanted to go home.
I think so.
Let it keep cooking.
Sabotage.
That was the one where we had over 4,000 people at the Civic Center.
Oh, my goodness.
So don't let any other committee tell you when they have 200, say 4,000.
And
Was
we
it-
transported all the committee chairs, so
Okay.
they had nice things to sit on.
Was it a hearing?
What was the bill?
It was marriage equality.
Oh, yeah.
Was it arson?
But it sure smelled like burned popcorn.
So just so that nobody resorts to burning popcorn in the electronic meeting world, we've been hard at work all day and everybody's put in a lot of time and energy and thoughtfulness. So we are going to move on to to vote on initiative 6. And then we have some language issues that Mr. Andrus brought to our attention. And we might have some other issues related to this that we'll need to wrap up. But let's start our work on the final initiative. Senator Sanborn, did you want to be recognized?
Thank you, Madam Chair. Yeah, so as we start our work on Initiative 6, or pick up our work, I guess, because we're certainly not starting. We've been here before. But as we return to Initiative 6, I just wanted to kind of lay out where I have landed on it and then make a motion. So I think that Senator Kine made an exceptional sort of observation and has provided some good sort of reality checks throughout our discussions today, and that hiring the folks in initiatives 1 through 4 or 1 through 5, I forget which one is the increase in rates, but hiring the folks in that set of initiatives that we have already discussed, as well as the folks in Initiative 7 that we have passed, is going to be quite an undertaking and is going to set us on a path where then I think in the second year of the biennium, we could accomplish standing up the pilot project for Kennebec County. And I would really like to see that pilot project get off the ground, but I want to do it well, and I want to do it at a time when there is the framework and the underpinnings that would be necessary to stand up a pilot project like that. And I also want to be very realistic to the AFA committee in terms of, having made some good choices about where we want to put the money. So I also thought Representative Libby's comment about being the policy committee and making those choices here as opposed to leaving them to AFA was important. At the same time, I am not willing to just take the pilot project, take the Public Defender's Office out of the budget, because the Sixth Amendment Center has recommended that we do this pilot project. The commission has recommended that we do it. So we need to do it. And we need to do it all the way. This is not something we should just do halfway or part of the way. We should spin it up entirely. Now, it's possible we won't spend the entire first year budget, but that happens frequently when new programs are stood up because there's often a ramp up in terms of hiring. Still, you need to fund it as if it's funded for the whole project, so that in the second year or in the next biennium, that becomes the baseline, and that's the intention going forward, so that you don't wind up having, unequal funding going forward and never achieving the full staffing that was intended. So my motion would be for Initiative 6, but only funded in the second year of the biennium, and making clear that the intention there is that it's a pilot project that is stood up, but on a 1-year delay versus what we had anticipated. And I realize that's not the whole loaf, but I think that it represents a reality check and also a path forward to really fulfilling our obligations. And I really hope that the rest of the committee will follow in that motion.
Thank you, Senator Sanborn. I see 2 hands up and 3 hands up, and I want to know, is there a second among those who with hands raised? 2 seconds. Representative Babbage is seconding the motion.
Yes, may I, Madam
Yes.
Chair? I'd just like to say that I appreciate Senator Sanborn's commentary and agree wholeheartedly. I think it's important that the Public Defender's Office does happen during this biennium. I do think it's prudent to start it in the second year for organizational reasons, as well as with all the changes that we have proposed that I think are very exciting, and I appreciate the work of the committee today. I know that there could be people that want the whole loaf, and I know that some people are reluctant to go in this direction. So I'm hoping that the senator's motion gets serious consideration, because I do think it's a middle ground that allows us to go forward. Thank you, Madam. I second the motion.
Thank you, thank you, Representative Babbage. And I would just like to add that we are asking Mr. Andrus and the commission to engage in incredible capacity building over the next 2 years. And I also will be supporting this motion because I think that it takes into account all of the work that it's going to take to build the capacity of the organization. And it also takes into account the market and how, we want to have the time to recruit the best talent possible to make the pilot program really successful. And I think that this motion achieves that. And I appreciate that it does not meet the proposal of the commission, but I think that as the policy committee, it's important for us to evaluate and make those recommendations. So that's how I'll be voting as well. Representative Evangelos, would you like to be recognized?
Thank you, Madam Chair. I've heard the arguments. I don't agree with them. Why don't we consider funding 2021 and 22 at like half the amount if the concern is that it was going to take some time to get it up and running and they couldn't possibly spend the full $2.6 million? Why don't we fund it at $1.3 million and get them the startup money to get up and go in the first year? That would be a lot better proposal for me to accept, and would take into consideration the concerns that have been addressed to me that we couldn't possibly spend the full budget the first year anyways. The other thing I'm concerned about is this whole business with COVID, and we don't know what the future holds. And, we could be faced with another financial crisis and another supplemental budget down the road, and we don't take a stand here. I guess the biggest problem I have, whether it's Native Americans or poor criminal defendants, they can always wait. Now they're going to wait another year to get adequate defense counsel. And I just, it's the same marginalized groups that live their lives on something called slow time, while the rest of us go along our time, normal time. I'm not willing to wait any longer. We've been doing this since 2019, Madam Chair. This isn't like new news to us. It was April of 2019 that David Carroll issued his report. So we've had that 2 years. So that's 2019. And now you're telling me it's going to be 2023 till we get this thing up and going. That's 4 years. We'll see what happens. I think these half measures we're taking aren't going to be viewed upon favorably by a lot of advocates, including the Sixth Amendment Center. We are not talking about a lot of money here. We just aren't. I told you, it's 3/10,000ths of 1% of our budget. And I don't see the police state making any sacrifices. They get everything they want. But here we are, shortchanging the indigent defendants once again. We could have easily funded the first year, at least at half, to allow the office to get up and running. So I want to make sure my dissents are noted. I'm not voting no. I'm voting no because I wanted full funding. I want the Appropriations Committee to know the substance of what I'm dissenting about. I don't want it to look like we have a unanimous report technically because we want to vote yes for something. I just don't want to vote yes for half measures. I've heard the presentations from the commissioners, from Justin. They've convinced me. The other thing we could have done is pass the full funding and then send a letter of attachment and set up our priorities with the Appropriations Committee. So if they had to reduce something, we would have announced what our priorities were. It would have been a slightly different approach. But anyways, if I do dissent, I don't want it to be a no, I'm against the funding. It's no, I wanted full funding. So I want to be assured that that's what's going to go to the Appropriations Committee.
Thanks for sharing your position, Representative Angelo.
Who assures me of that?
I guess I'm not. Are you? It depends on what your vote is. And I thought you were going to vote to have a minority report.
Right, I did last time. I just want to make sure that report, is that how it works? They'll automatically get it?
Yes, it all goes to the Appropriations Committee.
Thank you for answering that.
Yeah, I'm sorry, I misunderstood your question. Thank you. Senator Sanborn?
Thank you, Madam Chair. Yeah, I just wanted to address Representative Evangelist's question about why my motion didn't include partial funding in the first year or split the funding between the 2 years. And the reason, there are a couple of rationales. One is the capacity building that I described. I think setting up supervision, auditing, appellate, and I'm forgetting one of the offices, but setting up all of them all in 1 year, and then also launching a full-fledged pilot project for a DA's office would be, a public defender's office would be very difficult. So some of it's just sort of trying to be practical there. And then the other piece of it is because I very much want to put a stake in the ground for the full funding in the second year, so that the baseline is set, and so that we're not in a position where, rather than having 14 attorneys in this office, which is what the Sixth Amendment Center, I believe, tells us is necessary, we never wind up with more than 7. And then we are constantly not actually accomplishing the goal of having it be a demonstration of how it should run. So I want to do the whole thing and do it really well at a time when we're ready to, with the whole funding that's needed for it. So that's sort of the summary of how I arrived at the motion. I recognize that I'm not likely to convince you, but I did want to just share that with the rest of the committee in terms of why I thought of it that way.
Thank you. Representative Moriarty?
Thank you, Madam Chair. I have great respect for Representative Evangelo's sincerity and commitment. It's something I admire greatly. However, I do come down on the side just articulated by Senator Sanborn, and I won't repeat the reasons in her analysis. I would remind everybody that earlier today, it seems like days ago, but it was actually just hours, we did strongly vote for initiatives 1 through 5, and more recently initiative 8. So I do believe that we've made a good, genuine step forward in achieving the overall goal at a time when we have we're in possession of the ball, so to speak, and we don't give up possession of the ball and risk losing everything. Thank you.
Thank you, Representative Moriarty. Senator Keim? We're not able to hear you. And I just
Sorry.
wanted you to know I said that twice. Once I was on mute myself. Go ahead.
So I'll be voting against the pending motion. I do see this in our future for Maine and want to get there, but for reasons I've already stated, I want to make sure that my vote is pointing to the priorities that I believe hopefully have a chance of getting through AFA. But aside from that, this keeps getting referenced as a pilot project, which to me seems time limited. And I didn't assume that was the intention. So I just wanted to have clarification on that. I didn't assume that this was going to be a pilot project. I assumed this was going to be a public defender office because I don't know of any time limit having been set.
Thank you for raising that point, Senator Sanborn.
Thank you, Senator Carney. I think it's geographically limited as opposed to time limited. That makes it a pilot project, Senator Keim. At least that's how I think of it. So the geography of it is what's limited. We'll test it out there, stand up the whole office, see how it works in that one county, and then it would potentially be implemented in a couple of other parts of the state, but potentially not even in the whole state was sort of my understanding of it, because you need a certain density of cases in order to make it make sense. But perhaps it is doable in all these places. So I think that was kind of what I've heard, but that's what I meant by pilot project is geography, not time.
Yeah, that's a correct description. Committee members, would anybody else, is there any more discussion on the pending motion, which is to pass Initiative 6 with respect to the 2022-23 year of the biennial budget, meaning that the program would go into effect on January 1, 2022. Excuse me, July 1, 2022. I'm not seeing any more discussion. And so at this point, I think that we are ready for the vote.
Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
No.
Senator Keim votes no. Representative Harnett.
No, and I would like a minority report that I would have funded as proposed.
Representative Harnett votes no. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
No, and I would like my minority report to show that I would have voted to fund it as suggested.
Representative Sheehan votes no. Representative Hagan. Representative Downs.
No.
Representative Downs votes no. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Evangelos.
No, and I'm on the minority report as outlined by Representative Harnett.
You. Representative Evangelos votes no. Representative Newell. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. 4 members voting in the affirmative. 7 members voting in the negative. 3 members are absent. That is a vote of the committee.
Thank you very much. And just so that the reporting is correct, Representative Harnett, can you again recite your minority report in which Representatives Sheehan and Evangelos join?
I would have voted ought to pass on initiative 6 as it was originally drafted.
Thank you. And then Senator Keim and Representative Downs, Libby, and Poirier, are you a straight no on initiative 6?
Yes, ought not to pass.
Thank you. Peggy, you had a question for us?
That was my question. Thank you.
Great. And Representative Evangelos, go ahead. Did you have something you'd like to raise?
Yes, I'd like to, it was indicated to me if something didn't pass, I could make another motion. I'd like to make one. I'd like to make initiative 6 ought to pass as Mr. Andrus has outlined here.
Madam Chair?
Yes, Representative Babbage?
No, I was just going to ask that it actually, I was under the impression that it wasn't formally minority and majority reports, that we were putting out separate reports. And that if we were to vote again, it would merely be, unless we reconsider, that would merely be the same report, only expressed again. Is that not the case? I mean,
I think that is the case. And I also know that we have 3 members who have not voted. Representative Evangelos, do you think that Senator Sanborn, you've probably been in this position before? You want to shed some light on the situation specifically with regard to votes on budget matters, which are a little different than committee reports on bills?
Yeah, and Peggy might want to weigh in as well, but you know, we have completed our work on a report back in my other committee, and it takes the form of a memo that can have as much narrative as the committee wants to put in it. And so under initiative 6, I would assume that Peggy would capture the 3 different positions of the committee and would explain those 3 separate positions, and then would note how many people favored each of the 3 positions. It's not the same as a committee report, because in fact, this is actually a straw poll. This is not actually an official recorded roll call vote, but it's recorded in the form of a memo that our analyst will send back to AFA. Peggy, if I got any of that wrong, definitely let me know, but it is a straw poll as opposed to a formal report of the committee that would need, for example, legislative language that would have to go through the revisor's office and so forth. It's captured in a report instead, a report back memo instead.
And even if you did keep voting, right now you have a 4-4-3 split. So unless people change their votes or the 3 people who aren't here all vote on one side, you would never have what you would call a majority report. So you just have divided reports. You have a plurality of reports. What is that what we call them? Rather than having a majority report here. So I'll just spell it all out in the memo, and it will also be addressed in voting sheets. So appropriations can see how it's been split. But I mean, you have 8 initiatives, and a few of them are unanimous, and the rest are divided. So I have initiative 2, initiative 3, initiative 6 and 7 are all divided with folks being absent. So I mean, yes, it's a memo. I'm not sure how much detail I'll be able to get into between now and Thursday.
Excuse me.
We have an appointment with appropriations Thursday at 1 o'clock to present this, and you can make your case for each of these pieces. I'm assuming you will want to focus your time on the Maine Commission on Indigent Legal Services rather than the other pieces of your budget. But they have blocked out, I believe, an hour for you to discuss it with them. So I think that's a really good opportunity for you to explain your positions. I'll have a report for you to look over tomorrow during your marathon public hearing, and you can, present that on Thursday.
Is that satisfactory to you, Representative Evangelos?
Well, I'm glad we're going to have an opportunity to explain our votes to the Appropriations Committee, but the thing I'm really concerned about is we have a new executive director who has worked tirelessly to produce recommendations to us that have gone through the commission that have been working on this for a year now. And we weren't even allowed to vote on the proposal. This proposal, I'm sorry, but it was the product of caucuses, which did not receive any public vetting. And then they come in and make a motion, which isn't what they recommended. So we didn't even give these people the honor of voting on their recommendation.
I take issue with that, Representative Evangelos. I think that we've had extensive public hearings on this aspect of the budget, and we have discussed it, and we've really carefully vetted and weighed all of the competing policies, and we don't all agree, but I think that we're all working really hard to fix the problem in the ways that we think are the most appropriate approaches to the problem. And I would just ask that you take that into account in your perspective on this. And again, you you're a strong advocate. You have very strong policy preferences, and we'll have an opportunity to speak to the Appropriations Committee on Thursday. And I think that you should share the same passion and perspective that you shared with us today at that meeting. And I hope you do.
Well,
We all had a voice.
I do understand that. I'm just wondering what the commission and Justin are thinking right now when we don't even get an opportunity to vote on the numbers they put in front of us. And quite honestly, you know, the deal that got brokered was the product of secrecy. The public didn't get to hear any of it. I agree. We've done everything that you just stated out in the open, and we've worked hard and diligently. But in the ninth inning here, it didn't happen that way. It happened in secret caucuses. This deal was brokered, and the commission, nor Justin, nor myself had any input on it whatsoever. You know, a motion was brought forward, the product of secrecy. That I had no piece of it. I don't care if
I'm
it
going to interrupt you there because I think that you're mischaracterizing
I'm
the
not. I'm
purpose
telling
of
the truth. I know it
caucuses.
hurts,
that-
but I'm speaking truth to power here, and that's exactly what went down. We didn't get to vote on their proposal. An alternative proposal was brought in, the product of caucus meetings that the public had nothing to do with. That's it. I'll stop.
Thank you. Senator Sanborn?
So with regard to Initiative 6, I will just note that there was no deal. Our caucus was divided. We didn't agree with the Republican caucus on it either. So I just need to press back a little bit as the person who made that motion. It was not a deal brokered in any caucus because in fact there was no deal. It was a proposal that I made, having listened carefully to and considered in large measure Senator Kimes' salient comments about the reality of how things would unspool, and Mr. Andrus's comments about what his priorities were and how he would stand up all of this. I'm not saying Mr. Andrus wanted me to make the motion that I did. I think he probably wouldn't have wanted that. But my job as a policymaker is to take all the information, all of which, by the way, I had on this Zoom call. All of it was in public. I have not spoken to Mr. Andrus. I have not spoken to Senator Kime offline, right? So all of it was done in public, and then I made that motion. It wasn't a backroom deal. It was in fact a product of listening carefully during this hearing and having an open mind as to how this could play out and how we could present it to the AFA committee in as persuasive a manner as possible. And I really do mean that. And so I felt it was necessary to say that was the policymaking process that I went through in terms of how that motion came to be on the floor today. So with regard to Initiative 6, I absolutely take issue with the idea that there was any kind of backroom deal. Thank you, Madam Chair.
Thank you, Senator Sanborn. We have some language issues that we need to address with regard to the votes we've just taken. And I want to thank Mr. Andrus for pointing them out to us in his memorandum dated March 10th, because it's something that we didn't quite take into account. And I think we'll probably start with the first one, which was actually included within the budget work. And that was, I think, section FFF. Is that right, Peggy?
Yes, it is.
Okay, let's start there, and then we'll turn to Mr. Andrus for his comments on the additional language changes that we'll need to do.
I can share part FFF if you'd like. I have it right here on my screen.
Terrific, thank you.
So this is included in the budget. This was the governor's recommendation to, I think we talked about this briefly. The commission has rulemaking authority. Almost all their rules are routine technical, which means once they go through the rulemaking process and they finally adopt them, they become effective. There are two areas of rules that are considered major substantive, which means the legislature has an opportunity to review them. And those two areas are standards under subsection 2, so it's training and qualifications, as well as the rates of compensation for assigned counsel. So what part FFF proposes is to make those the rules about standards regarding attorney qualifications and training would be routine technical, which means they would not have to be reviewed by the legislature before they go into effect.
Thank you, Peggy. And I just want to turn to Mr. Andrus for a second, because I thought I recalled from our earlier work session that this was something that the commission was also in agreement on.
Yes, thank you, Senator. The commission asks for this change is certainly in agreement with it. Again, just when you're reading it, the summary states the proposed change backwards from the text. The reason for the change, and I know Senator Keim in particular had some questions about this the last time we met. As we go forward, we propose to implement a set of rules, and you've heard me talk about CPCS. I'm not going to do it now, but a set of rules for attorney documentation, caseload standards, things like that, and training standards. And that's why we've asked for all these training people. And so the reason for the change to make these standards routine technical is to give us a greater degree of adroitness in changing the rules to fit as we implement that stuff. Now, it's my hope to do it in as close to one fell swoop as possible at the change of the fiscal year, so that practically speaking, we're not looking at very many tweaks to it. Because I think it'd be difficult for everybody to navigate in a constantly shifting landscape. But we're going to need to be able to make our rules match what our operational standards are. I'm going to train myself out of using rules for that, because I mean that lowercase r. That's the purpose for the requested change.
Thank you very much. Do committee members have any questions about section FFF? Representative Babbage?
Just, I know we've gone over this 5 times, but this is about standards and not about rates, correct?
Correct.
Yes, Representative Babbage, that's correct.
Right. The summary that was in the bill is incorrect. And here, I will, real quick, I will just share this with you. This is the cross-reference to paragraph B, standards prescribing minimum experience, training, and other qualifications for contract counsel and assigned counsel. Paragraph F is the standards for reimbursement of expenses, and that's not being touched by this, by the language.
Thank you, Peggy. Are there any additional questions, Senator Keim?
Thank you. And I did ask this before and I forgot the answer. So just remind me again why it is that the commission wants to have this rulemaking not come before the legislature.
I think
the short version of that answer. I apologize for asking it twice.
No, I think that's a reasonable point to want to have a little reinforcement on. It's less about, we don't want legislative oversight of it. It's about adroitness, it's about agility. And so we're going to have some pretty sweeping changes in our relationship to our contractors, and also presumably some changes to our employed attorneys. You know, we don't, once we have some, and so I'm losing my finesse, excuse me, as I trip over my tongue. But the reason for it is to ensure that if we realize that we need to make a change in order to have the operational sort of efficiency and success that we're looking for, that we're able to do that most efficiently. That's the basis for it.
Thank you. Thank you. Yes, I remember reasoning through that now in my mind. And thank you, Justin. Today's been a lot for having, 13 people pepper you with questions for hours. You've done really well, and I appreciate you walking through all of this with us.
Well, I appreciate the time.
Yeah, and just for committee members and of course members of the public who may be watching, the routine technical rulemaking still goes through a notice and hearing process. It's just not at the legislative level during legislative session. It can happen outside of this context, but it's still a very public rulemaking process. Representative Libby?
Thank you, Madam Chair. And this is perhaps a very elementary question, but I just was wondering if we could have an example of some of those rules that might fall under this. I grasp the concept, but I'm having trouble figuring out the substance.
Sure, and I'm working on this other screen, not because I'm multitasking you, but because I want to get the citation for you. In our adopted rules and standards, there are a number of chapters worth looking at. Chapter 3 is the eligibility for case types, and I'm looking for one that, well, here's the homicide. You have to have 5 years of criminal law practice experience. You have to have tried a certain number of cases, 5 in this instance for homicide. Either done a homicide trial in the last 15 years or done one in second chair as a defense attorney for the past 5 years. And there are 3 more after that. Keep going if you want. But those are the kinds of things that are in there. It has, for example, demonstrated knowledge and familiarity with certain kinds of evidentiary issues, including DNA testing, for example. And so maybe that rule should be have participated in a commission sponsored or specifically approved DNA training. Maybe when we have training officers both presenting and identifying other training opportunities, we're going to be able to offer more to our folks and ask more of them in terms of their education. And so maybe it's appropriate then to say that we want our murder people to have done that. Maybe we learn about a change in jury laws or something, about selecting juries. We want folks in our, especially, I would say all, I'd like to say all, but particularly in our particularly high consequence cases, work with a jury consultant. And so maybe we have taken a class to learn how to work with that. I'll stop because I could, I love that stuff, so I could spend a long time on it. But there are examples. And so they're for homicide, sex offense, serious violent felonies, which we include aggravated trafficking as a serious violent felony because of the complication level, operating under the influence. It would make sense to me to do some restructuring so that they're a little hierarchical. They build on each other a little bit in branching, and then there's the details of what really should be in those requirements. I don't know if that addresses what you need to know, Representative.
It does. I just want to be sure that there's still the accountability piece there, that heaven forbid someone in the future thinks it's a good idea to dumb down the standards in some way, whether that's changing, the category of 5 years of experience to, if you've graduated 6 months ago, you're good to go. I just want to make sure that those standards can't be changed dramatically through a minor rule change.
I don't know that I can offer you the reassurance that that's technically or procedurally possible. What I can offer you is that my intent in supporting this change relates to my intent to have more precise standards in place. And I know that's my commitment to what I have in mind, and I'm still only the interim, so that's not as valuable as it could be. But I don't see how it would run in that direction. There may be some element we decide is irrelevant, drop from the requirements. That's a little bit different of a question.
And also just to reiterate, Representative Libby, any proposed rule changes would be posted on the commission's website and would be the subject of public comments, for example, by the defense attorneys. And so there is that same back and forth that we have in the legislative process. It's just that it takes place in an administrative setting instead of the legislative setting.
Yes, I appreciate that. I have seen in other areas, though, where so-called minor rule changes have been made and they really should have been categorized as major. And there really is, to my view, little recourse for that. Whereas here in the legislature, we have these prescribed steps. So that was my concern. And I think that Mr. Andrus has addressed it thoroughly. So thank you very much.
Thank you. Senator Kime?
Thank you, Madam Chair. I would make a motion that we move this in.
Is there a second? Seconded by Representative Harnett. And I think that we are ready for the vote. Actually, before we do that, I should ask, is there any more discussion on this measure? I am not seeing any additional discussion. Now we are ready for the vote. Thanks.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime.
Yes.
Senator Kime votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
No.
Representative Libby votes no. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. 10 members voting in the affirmative, 1 member voting in the negative, 3 members are absent. That is the vote of the committee.
Thank you very much, Ms. Panett. And now we have a number of statutory changes that Mr. Andrus recommended that pertain to initiatives 1, 2, and 3. And these are matters that we could either take up and submit to AFA to pass with the budget, although Peggy also suggested that we do have as an option a standalone bill that would address these issues. They're on page 9 of the March 10 memorandum. And Peggy, could you give us a synopsis on the procedural advantages or disadvantages of providing these to AFA to do in connection with the budget versus doing them as a committee bill?
Well, I think assuming appropriations would accept your recommendations, some of them really might be tied to the new positions and the new functions of the commission that you are putting together, like subpoena power. And I was trying to pull up all his language or all his.
I have it here in front of me and I can just kind of run down it.
So the first one, as soon as you're going to have attorneys who are actually employees of the commission or employees of the state that are going to represent attorneys, the concern is that the statute doesn't really authorize that yet. And so you'd have to amend that. So if you're having an appellate defender division, or you're having the Kennebec public defender division, you're going to need that language.
Mm-hmm.
So you might need to do that right away.
Yeah. And so do you think, I guess my question to you is, do you think that it makes more sense to provide this in legislation that we give to AFA, or do you think that we should handle it because there are a number of changes? Do you think that it would be easier for us to handle it as a standalone committee bill?
Well, it might be easier for you, but I guess my concern is if they get separated, because you want to make sure that if indeed there's a public defender funded or the appellate defender funded, that they have the authority to actually represent clients directly.
Okay. And so then
I'm not sure his listed in addition. Those might be things that you can deal with in your own bill.
Okay. So do we have, and this, I don't mean to impose upon you because it's already quite late in the day on Tuesday, but the legislation that we would need to attach to our budget report back, is that something that you could prepare for us to look at tomorrow? Or is there some way that, for example, we could help you get that prepared for tomorrow? I'm happy to work on it with you if you need that.
Oh, I'm certainly happy to work on that and run it past Mr. Andrus and see if that meets what his expectations are and get it to you sometime tomorrow.
Are you sure that's doable?
Sure. Thank you for asking.
Well, we appreciate how hard both of you have been working, you and Mr. Andrus. And yes, so we're looking really at the first three items. Is that correct?
I mean, I don't want to speak for Mr. Andrus because I know that he proposed all of them. I think the first three are pretty important if you're going forward with any of the other recommendations that you've already voted on.
Yeah, I agree. Mr. Andrus, do you agree with the suggestion that we address the first three items in our report back with the budget, and that items number 4 and 5 can really be taken care of separately?
Yes, we're also simultaneously, we're looking in parallel to this process to draft a bill for a sponsor that would also potentially include these changes. But it makes a lot of sense to me for the especially for the budgetary implementation stuff for it to go together. It hadn't occurred to me they could be orphaned, but that would be a problem. So we then couldn't use the people. And I'm certainly available to Peggy to work with you tomorrow on language and that one.
Okay, and that seems like a doable goal for us for tomorrow. So thank you both very much. And I think that we have Senator Keim has a question. She and I have been talking about the financial order issue that we spoke about a little bit with regard to the supplemental budget. And I'll recognize Senator Keim at this point to explain the concern and ask some questions.
Great, thank you, Madam Chair. Yes, the last time that Jerry Reed came before our committee, he had said that with the leftover funds in the MCILS budget, that through financial order, the governor could give 2 temporary positions. And I would like us to further explore that. I've talked to some members of the AFA who have said they see that as possible as well. And that then we would have 2 positions implemented immediately if AFA approves. So it would have to come from the governor's office and AFA would have to approve it, is the process as I understand it, but they would be temporary positions. But as I see it, those temporary positions then could be made permanent as part of our initiative, whatever it is, initiative 1 today, so that we wouldn't be, hiring 2 people and then saying, well, this is a temporary position, but they would in fact have the expectation that their job would continue if at least initiative 1 passed through AFA. But, even if it didn't, I guess those 2 temporary positions would still, help get work done and help improvements be made. But why I would like our committee to still push for this is not only did Jerry Reed say that the governor was amenable to that, but as far as my recollection was, but I also believe that it will help the commission get going sooner with all of these initiatives. So if they had 2 extra man on deck kind of thing, that they're just getting going before the budget cycle even begins. So I would like for us to send a request to Mr. Reed and ask him to maybe speak with us about that or move this forward in whatever way that we can. I think it's important for us to get this going immediately.
Yeah, and I agree. And I think it's if the commission could start to build capacity very soon, it would be a tremendous advantage because again, there's a lot of work to be done. Peggy?
So I just want you to be sure where that money, why that money is there. It's because there weren't attorneys being appointed to take cases because of the shutdown. So it's not that those cases necessarily went away. They're kind of pending, they're building up. So it's not that that's really extra money. It's money that was identified for this purpose, but it hasn't been used because there aren't trials. The court activities haven't been happening. So there aren't attorneys who are engaging in those activities. So they're not filing vouchers. So I don't want you to think that that's just a little, pool of money that you can use. If you use it for this, that means there's going to be a shortage in the future, I think. And if I'm saying that wrong, I certainly want Mr. Andrus to correct me, but that's my understanding why there's money there.
So that, sorry, I'm presuming, Senator Carney, may I respond?
Yes.
So that is correct. That there is, if you've heard me talk about this in other sessions, there is a 53% year over year increase in cases, and someday that will come home to call. I think that as part of this conversation about funding into the future, also looking at section E, which is about the non-lapsing language, so that funds pull forward is important. The idea that we could have two able-bodied people on deck now helping to trim the sails would be really, really awesome. So I don't want to talk anyone out of trying to go down a road that lets us start this process sooner than later. I just want to set realistic expectations about what happens when those cases come in, so that everybody has a fair expectation. The idea of having folks today is a little thrilling. I know it's not quite today, but.
Thanks for providing that information. Senator Sanborn?
Thank you, Madam Chair. Yeah, I think given where we are in the calendar, I think we should press Mr. Reed quickly to move two positions forward. I thank Senator Kine for bringing that back up. And maybe as a suggestion to Peggy, maybe we write a letter as a committee directly to Mr. Reed and then attach our AFA report back and explain to the way in which the two temporary positions would flow into the report back and the union and highlight the unanimity on our committee. And then we should copy that letter to the AFA committee as well. So that would be my suggestion as to how to proceed procedurally. And I think this is, given the reality of how long it takes to hire someone, we're really only talking about funding probably 2 or 3 months of salary for 2 people.
Mm-hmm. Senator Kine?
Thank you, Madam Chair. Yeah, I fully understand what Peggy said about the fact that we are taking money that is due to unusual circumstances left over in the budget, but I think it is making really good use of it. And I understand that eventually when courts get up to full capacity, we'll have more cases, and then, expenses will grow at that time. And who knows how long that ramp up will be. But in the meantime, I am very satisfied that it's a good use of the money.
Do other committee members want to weigh in on this before we move forward with a draft letter to Mr. Reed? Sounds like everybody's satisfied with it. Thanks, Senator Kine, for bringing it up. And it will be great to build capacity in advance of that anticipated surge in caseload. See, I think we have one more language issue to address, perhaps. Mr. Andrus, was there something else that you wanted to raise?
a scary question after the day I just had in front of
I
this committee. So
know.
thank you. So there is the executive director language. Peggy and I will do that tomorrow as part of our statute change stuff. Because that needs to be implemented. And then there's language about general funds not lapsing. And I apologize. There were two versions of it running around, and I copied and pasted one that had language about FY22, but not FY23. Peggy, I sent you earlier today in a swarm of things, an updated version. But when you look at Part XX on the very last page of that memo, there should be 2 paragraphs. There should be XS. There it is. XX2 should also be there. This is just to bring that funding forward, make sure it doesn't lapse.
Thank you very much, Mr. Andrus. Committee members, are there any questions about these provisions? I am not seeing any. Oh, Senator Kime?
Yeah, so I'm assuming that tomorrow we're going to talk through these. Is that the plan?
Yeah, I mean, I think if we have concerns and questions about them, we should probably address them now so that if we need additional information, we can get it tomorrow so that we can resolve everything. So do you want, Peggy, do you mind returning to screen sharing? And then we can take committee questions. Senator Kime, did you have a question?
Yeah, so I guess what I was looking, so I don't know where, I'm sorry, but oh wait, maybe it's here. Okay. No, is that it? All right, so my language just looks a little bit different, maybe. I don't think I have the same language in front of me that Peggy now has there.
That's, yeah, none of us do.
Okay, so then this one part XXX is about just one fiscal year of making sure that they carry their balance rather than having it be swept into the general fund.
Yeah, I think it's 2. We can ask Mr. Andrus. Go ahead.
For the 2 years?
Yeah, there's
one section for each, right?
Okay.
I'm gonna stop sharing so you can see each other.
Let's keep it up for another minute.
Yeah, so is that the only language that we're approving? Because I thought we also talked about some of the things I see in this memo dated 3/10.
So there was money in the reserve account that appropriations had set aside. It was really last year. The supplemental budget took it out of the reserve account and put it into their other special revenue, and they do have authority in the supplemental budget to spend that. So for the current biennium that ends in June, they are all set. They have that authority to spend it. And I think that's, I'm sorry.
So what is the reasoning behind wanting their leftover funds in the next 2 years, 2021 and 21-22, not to be swept into the general fund? So it's a change in policy of how we've handled the funding for MCILS. So what's the reasoning behind that?
Well, actually, the funding for MCLS hasn't been a general fund account for 2 or 3 years, at least. And the general rule for general fund accounts is if there's money left in there at the end of the fiscal year, it does get swept, and that becomes surplus. And Mr. Andrus might want to address any specific parts of that.
So from my perspective, it goes to funding funding the foreseeable shortfall from the period when the other cases come home. And so it's effectively $2.6 million that in the ordinary course would have been spent, but the ordinary course didn't occur the work got deferred, but new work's accruing at close to the standard rate. And so I think about it as essentially encumbered by the cases that got filed but not resolved during the pandemic shutdown. I'm encumbered, I mean, with a lowercase e. It's not, but that's what it's booked, that's what it's earmarked for. So if we didn't have it, then the need for a supplemental budget allocation would be enhanced by that amount whenever we get to that day when those cases are coming in. And it'd actually be over a period of time, it won't be one day, but.
Yeah, so I understand. I understand that, but so then you're assuming, I guess, that the courts aren't going to be up to full capacity even in 21, 22, and that there's going to be excess funds that you believe should stay with the commission as opposed to going back into the general fund.
I would only tweak that rather than saying I'm assuming it won't be back up in 21, 22. I would say I believe it's likely that the knock-on effect of the closure will extend further than that 1 year, and that I don't know how quickly it's going to come or when it's going to come. And so I don't know for certainty that enough of that increased flow is going to occur next year that it'll soak up all these funds. It certainly does not appear to be the case that it's going to happen before the end of this fiscal year. Courts are starting to talk about jury trials again, but not at a rate that clears the backlog.
And so this provision, Part XXX, will allow the commission to use money that wasn't spent in this biennium because of the pandemic to fund what we expect to be a heavier than normal caseload in the next biennium, in the coming biennium.
That's correct.
Is that essentially what's happening?
Yes.
Okay. Are there committee members, other committee members who have questions about this? Peggy, can you switch us back from screen sharing so we can see each other? Thank you very much. Committee members, are there any more questions about this? I'm not seeing anyone. Is there a motion? Senator Kibe, do you have a question or a motion?
Sorry, I had further questions about, is there more language than just this that we would be discussing, but I'm interrupting the motion, so I'll defer.
I think that this is the only language we'll be discussing on this matter. The other language that we needed to discuss, we've addressed by voting on Part FFF, and then by deciding that the items listed on page 9, items 1, 2, and 3, that Peggy and Justin are going to work on some language for that to give to us tomorrow. And then the items on page 9 of the memo in paragraphs 4 and 5, we're going to do separately as a committee bill. So I think, and Peggy, I may be wrong, there may be more, but is that it for us? Or is there some other language that we're going to be working on?
I am not aware of anything else. I don't know if Mr. Andrus has anything else that he needs you to take up.
No, thank you for taking up so many things. But that is all of the things I have for you.
It's there. We've been dealing with a lot, and I think we've done a great job. But yeah, I think we've got everything covered, Senator Keim. Did you want to make a motion?
Yes, I would make a motion to move Part XXX in.
Thank you. Is there a second? Representative Libby is the second, and we'll do our final Roll call vote on this language. Thank you, Ms. Panett.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. Representative Galgay-Reckett. Representative Galgay-Reckett is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. 10 members voting in the affirmative and 4 members voting in the negative. 0 members voting in the negative, 4 members absent. That is the vote of the committee.
Thank you very much. Committee members, is there any final, I've lost my tongue, items to take up? Peggy had her hand raised before you did, Representative Babbage. So Peggy, you have
Great.
the floor, the virtual
I
floor.
will, of course, defer to Representative Babbage.
Well, you do not at all necessary, but I will take your, I'll take the opportunity. I just want to say Peggy and Soupy are too nice to mention this, but since we've had so many people violate it today, I want to mention that, you know, when a defendant goes before the judge and they ask, how do you plead? There's only 2 answers. And when there's a motion on the floor and we're being polled, there's only 2 answers, yes and no. So if you have a minority report, you're not supposed to debate during a vote. So the point is to vote yes or no, and then you will be polled by the chair or Soupy or Peggy for your minority report, and you'll be able to orate at that particular time as to the reason for your thinking, because I know many times I've been a lone dissenter and have been waiting with great anxiety that I'll get the opportunity to explain my brilliant dissent. But it does, yes or no is the appropriate answer to the question. Thank you, Madam Chair.
Go ahead, Peggy.
Thank you. Well, speaking of yes or no, I have I had posted the voting sheet from the 9th, and you did take 2 more votes on the original voting sheet. There are some folks who were absent for some votes. And if you want to be recorded, if you could let me know, I would really appreciate it. I know that, I mean, we voted on the 3rd and the 9th and now the 16th. And so it's very likely that somebody wasn't here for one of those votes. I'm happy to go through all of them with you individually or whatever, and I will email you the voting sheets if you want. Or you can just be recorded as absent. That's fine too. I just don't want to disenfranchise anybody.
So this process is a little different than when we vote on bills. If you're absent to vote on a bill, you report to leadership. And for this process, if you want to cast a vote when you are absent on a budget vote, then you still have the opportunity by communicating with Peggy. So do you, Peggy, I think it would be helpful for committee members if you could circulate the record of the votes around, and then
Yep, I'll send that again.
And what is the deadline for folks to get back to you?
Probably the end. Yeah, I'm just trying to think how we put all this together in time to get it to appropriations. I mean, I guess we really don't have to get it there till Thursday morning. So the end of tomorrow would be really good. What I'll do is what I can circulate right now. Well, no, I don't, because I have to just update it with today's votes. I will circulate it this evening. How's that? And so there'll be two pieces. One is what appropriations gave us, and the other is the new one, although I'll still have to add on the language that that Mr. Andrus has recommended.
We appreciate you doing all of that. And it's a rush to get this to the Appropriations Committee, and we appreciate you spending your evening on our budget report. Thank you very much.
You're welcome.
Other questions or items to take up before we adjourn? All right, is there a motion to adjourn? No? Yes. All right, Tom has a motion. All right, everybody, see you tomorrow morning. And Peggy and Soupy, thank you so much for hanging in there with us all day today. Good night, everyone.
Thank you. Take care.
Thank you. Thank you, everybody.
Good
Bye,
night.
thanks.
Soupy, I'll send you an email in the morning. I have the SL&G meeting and I have a work session tomorrow, so I need to be there for voting.